I think this is working. Good morning, Sarah Boone rewatch crew. As I'm digging around, got a little late start here today. It was way too warm in the Dandy True Crime Attic. That's correct. That is correct, Belle. Right. I've got my medical snacks. I've got my medical drinks. Checking with the chat. You guys have been super active. I'm a little frazzled. Not quite fractious, but a tiny bit frazzled. Thank you, Christina Garcia. Yeah, the court should have kicked my bunk at 3 a.m., Detective Wobbuffet, but there was nobody there. To tell the truth, what happened, usually I try and go to sleep visualizing my show. So I'm like, okay, I'll do this, and then I'll do this. Oh, that would be fun if I do this. And so I try and get, just some positive thoughts going. Anyway, last night, all I could think about was technical difficulties, and I was stressing out. I almost felt like, you ever seen the show Quantum Leap with Scott Bakula? I felt a little bit like I was, like I leapt into my body. So I knew intellectually, I had a stream to do and stuff, but a lot of imposter syndrome where you just felt like, okay, I guess this is what I'm going to do. It just, felt a little out of sorts. Another one to say has been holding down the porch. Thank you, another one. Kelly's here. FUD. What is FUD? I remember FUD. FUD is... I remember what FUD is. It's an acronym I know about. Holy crap, there's no way I'll be able to catch up with all the chat. My God. You guys did have a good time before I got here. Okay, well that's good. We've got some really good Sarah Boone stuff today, so that's exciting. I'll do a little recap. If anybody was part of the puzzle stream last week, I'm a little embarrassed. I was having a good time. There's two sides of it, because on the one side, click on your encoder to start preview. Okay, no. Wondering, maybe the connection's not as good here. Anyway, on the one hand, I kind of realized maybe don't endeavor to do things when I know that the plan is to be drinking a magnum of wine. I'm not going to be very professional by the end of the stream. And that was true. I was watching it back and was having fun watching the first hour, even hour and a half, and things kind of took a turn to where I didn't like what I was watching. And so I privatized the stream. I'll go back and watch it. The lesson I learned was, even with the best of intentions of a good day, too much alcohol can make a day go bad. And it actually ended up really proving Sarah's story wrong, because even if we take her at face value for a lot of her story, the reality is that things were going to go bad. They were always going to go bad. If not that night, some other night. But you can't keep drinking at that kind of level without expecting something bad to happen. So fortunately for me, all that happened was I got a little short explaining copyright rules and didn't make much of a puzzle after 2.5 hours of puzzling. So there was that. But there's some valuable footage. There's stuff that can be useful, but it's not my brightest day as a podcaster, that's for sure. I did have something to look up too. Anybody's watching McKenzie Shirilla in the Crash? I thought it was that was a pretty good documentary. Obviously super apologetic, but had just enough of the facts in there that anyone with a bit of a brain would be able to parse through what Steve and Natalie are saying on Mackenzie's behalf. The reason I was taken with this, and maybe I can get a picture up before before we get started here. I don't know who told, or it's obviously no one told McKenzie. McKenzie said, you know what, I'm going to be on TV. I want you to do my hair. I want the hair and makeup team in here. And I don't want just any hairstyle. I want a hairstyle that's going to make me look innocent as fuck. So give me the Corey Richins innocent as fuck look. And yeah, they did. McKenzie showed up at the end of the Netflix documentary looking, innocent as fuck. Let me see if I can find that. If you are into McKenzie Shirilla coverage, I definitely recommend AG Tactical. He was covering it really well before it all blew up on the Netflix movie, documentary, show, whatever you want to call it. There it is. There it is. Okay. So yeah, who wore it worst? That's we're gonna call this side part the innocent as fuck look. That's what I'm gonna call it. Drink that back down. Something to think about there. Gives me a chance to get my rest of my stuff together. Get the chat going on my phone here. Okay, clearly my audio is working. That's good to know. A to B, if you haven't seen The Crash, because I thought I knew the case super well, I'm like, I don't need to see The Crash. You pretty much know the whole story here. It was pretty good. Pretty bad for for the apologizing for McKenzie. There's a lot of people that, went out on a limb to kind of justify her actions. That it was still interesting. I was glad they got that footage, but I was glad they also balanced it with a lot of people who were saying, no, that's bullshit. And as soon as you watch that, you can go on to YouTube and start looking up what they didn't show you in The Crash, and you'll get all the other story too. But Disney Mom says, I don't have Netflix, but what I've seen of the parents' interviews and phone calls, all three are horrible human beings. I would concur. I think that there's a lot of nurture issues, and apparently McKenzie does have a sister that, not into trouble, and all the best for her. You don't want to, rope everyone in by association. But yeah, the parents super permissive, and not permissive in hey, I'm a reasonable dad, I just want the best for you, but permissive in a wildly dangerous to your child sort of way. Permissiveness, oh, well, she's going to do what she's going to do. What can we do about Kinsey? Anyway, not a fan of the dad or the mom. The mom, I lost a lot of, didn't really have a lot of respect for, but it didn't gain any listening to her do the phone calls. And then the dad is such a weird apologist. Minimizer apologist. The funniest part about the dad and mom is the way that the mom kind of, you're not being supportive enough, Steve. No, that's not right, Steve. Poor Steve. Like, he's already in the bag for them, and it's like not enough. Anyway, I see we have less than a minute left. Let's get started. LCB is a mod for AG. His lives are great. Annie Elise is another good one for McKenzie. That's true. Yeah, I did see Annie Elise. Might have been one I was watching as I fell asleep. Let's switch it over to the watch screen. I don't have a huge graphical package. I might start adding stuff as we go, but as it is right now, I went as bare bones as possible to get the stream started on time. We will get started with, this is Sarah's first appearance since asking to have the handcuffs removed so that she can operate freely like the other lawyers while she's acting as her own best advocate. It started, and from what I remember, there's about 6 minutes of chatter That white noise you hear is from the original audio. We can chat it up a little bit while we're waiting for the courtroom audio to start. What are some things that I had as notes that we want to watch for this? Well, if you guys have seen the shorts, one of the things I realized is freaking hilarious is slowing down Sarah's voice to about anywhere from 25 to 40% gets us a great drunk Sarah voice. So whenever she says something super stupid, or anything that you guys want to hear in drunk Sarah voice, just type drunk Sarah in chat and we'll rewind it and listen to it slow. Bill for Dom Russo corrects me. Dan, it's pronounced Shirilla. That's true. There is a rumor that McKenzie Shirilla's nickname at the prison is the Poopy Pants or Shitty Crack or Shitty Ass or Shirilla. Anyway, apparently she doesn't wipe her ass, and she's earned a nickname amongst her peers. So, Unshackled and Unprepared. That's right, Kel. Yeah, here she is. I am unhandcuffed yet unprepared. Now I know it looks like there's people talking, but yeah, I just turned on. There's no courtroom audio yet. We don't know what he's saying. Oh, this is right. So this is, I think the audio works when she comes up. But this is the media lawyer. She makes a fantastic argument for why the media is allowed at any hearing. I think right now she's just introducing herself. She'll go have a seat. I think the audio picks up pretty quickly after she sits down. But yeah, she makes fantastic arguments for why the media is allowed. It's not a matter of, is the case interesting enough to warrant the media? It is the case sensitive enough to disallow the media? And the main argument this lawyer makes is that she's never seen in Florida. Whoa! Okay, there's the audio. Going to turn that down just, well, let's see.
Address the factors.
Okay, we'll give you a 5, 4, 3, 2, 1 on the audio at full volume. Let me just go back to the main. All right, audio at full volume in 5, 4, 3, 2, 1.
Under the case. My intention for this afternoon is to have Ms. Boone proceed first with anything that she'd like to tell me. I will hear from.
And what I'm going to do is give it a chance to dial itself in. A lot of times they'll fix the audio in the first couple seconds of the audio coming live, but if it doesn't fix it, I will make some adjustments in studio.
The state, if they have any position on the matter, and then I'll hear from you, and then the court may be in a position to make a ruling at that time. Okay? Yes, ma'am.
Have a seat back there.
Wherever you feel most comfortable.
And just sit back there while
Okay, thank you.
until you're ready here.
Thank you, ma'am. All right, Ms. Boone, you can proceed, ma'am.
First and foremost, I do not know what it is that you are referring to.
When you say you do not know what I'm referring to, what do you mean?
Motions were filed by the WFT.
First off, I don't know what you're talking about. Well, good for Sarah for being honest to get started. What is the award on the judge's bench? I've never noticed that before, Phil for Dom Russo asks. Look. Looks like some sort of a glass award. You're right, just behind his monitor. I would imagine it's something to highlight his jurisprudence, but hey, RN2 moms, welcome, welcome, welcome. The audio is going to be a little touch and go to start, but they'll dial it in. I was able to listen to this whole hearing, and it's not too bad after the beginning.
Be in the Orlando Sentinel?
Yes, ma'am. So there was a motion to intervene for the limited purposes of opposing closure that was filed on August 12th by WFTV.
Here we go.
It was sent to you by U.S. mail at the correct inmate legal mail address on August the 12th, and the Orlando Sentinel's motion to intervene and notice of joinder was filed on August 13th, and it reflects It said the certificate of service was August 13th, and it was sent to you at the same legal mail correspondence address at the Orange County Jail. Have you received either of those motions?
I have not.
Okay, I have
I have
copies.
not.
I think that's for copies.
Oh, perfect. All right.
And I do apologize on the Sentinel one, but the e-portal was down for a little while, so while we attempted to file it yesterday, it actually got filed.
That's why.
So if you didn't hear her, she just said, I apologize for the Sentinel one. The portal was down yesterday. I wasn't able to file it, so I just filed it today. Doesn't seem important, but it ends up being important because Sarah didn't listen to her, even though she's sitting right beside her. I was able to hear it through the secondary microphone, but Sarah complains. And which I'm just receiving today. Well, yeah, it got filed because of the meeting. The last case we watched was August 9th. The day of today's hearing is August 14th, so 5 days have gone between. There's a weekend in between there, too. So when Sarah starts complaining about not knowing what's going on, it's like, you got told there's a hearing? Here's your chance. Learn what's going on. You're your own best advocate. Hello, Detective Wilbittet.
Saying it, the certificate of service reflects the 13th, but the filing information is of this morning. All right, Ms. Fugate has, I am pronouncing your name correctly, am I not?
Yes, if you take your own.
Thank you. Ms. Fugate.
Charles Grieve, if anyone's just arriving late, Charles Grieve has a summary of what you've missed so far. First and foremost, I'm a stupid POS, Your Honor. That's correct. That's what we've missed so far.
Fugate has provided copies of those motions. So Ms. Boone, if you'd like to take a look at those, feel free to take your time to review them. And then after you've reviewed them, I may have the opportunity to answer any questions you have about them if I can, and then we can proceed.
So fun part here, we do have...
Also, the circuit court cases that I know are in a report that might be hard to find, I have extra copies of those if anybody would like them.
If you want to provide those to Ms. Boone as well, you can do so. Thank you. State, do you need a copy of them? Thank you. All right, thank you, sir.
So what we'll have here is the media hands Sarah a copy of the case law regarding cameras being allowed in the courtroom. And because Sarah's just been given it, Judge Kraynick is saying, well, you have the opportunity now. Review the ruling. They'll fix this audio again. And this is Sarah's, this is one of many moments that come up in the trial where Sarah's like, oh, well, all eyes are on me. Well, I will take every second. So you can imagine, what is she doing there, right? At best, she's reading the order that says all the reasons why cameras are allowed in court. She's not going to have anything where she can rebut it or say, oh, no, but in, McKenzie versus Ohio, they said XYZ. So at best, she's just, reading it to understand why she's fucked. But that's not going to stop her from taking like a full, almost 10 minutes. Almost 10 minutes. The good thing about this particular part, remember this by the end of today's video, because Judge Kraynick gets served a motion from Sarah, and he turns the tables. He's like, oh, well, if everyone can just sit back while I review this. And he sits there and almost, I felt like it was vindictive. I felt like it was intentional. Not malicious, but at least intentional. Where he's like, I'm going to review this on your time. But he's so good at not looking at her. Like all of the people right now, the cameraman's kind of moving around the room. But it's basically showing how everyone is finding something else to do. So they're not staring at Sarah, And Sarah, all she wants is people to be waiting on her. So the more people are like, no, take your time. I'd just like it to be known, please, that I just got served this morning and was not prepared. Mr. J, Mr. Cacciatore, statues.
If I may say, Your Honor,
Yes, ma'am.
If I may say, Your Honor, you didn't respond to if I may say. Yes, ma'am.
one of my topics of discussion, as you know, are the requests in regards to the laptop and internet being one of the most important. Would I have had access to that, I would have already had this and not.
So this is Sarah not responding to the motion, which is about whether media should be in court. This is her throwing shade on, well, if I had the laptop and the internet that I asked for on August 9th, I would have already known about this. I wouldn't be wasting all your time. So, your fault, not mine.
I had to sit here unprepared. I believe that is a major violation to my due process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So I wanted to put that out to you that I am unprepared for this.
Ding! We're going to give a shout out to Luther Rose from Detective Wolbefit just because that makes people smile. Probably is going to make Luther Rose smile. So there you go, Detective Wolbefit. And thank you, Sarah, for pointing out, just putting it out there that she is unprepared for this. So anyone who was fooled, anyone who was watching her thinking, wow, this is the most prepared pro se inmate I've ever seen. Not.
Process of me not having these in advance to prepare properly and to utilize the court's time and everyone else's here by me having to do this now. So
she's not doing a good job of pretending she cares about the court's time. Like, good to throw in there, but when you have such a record of wasting the court's time, you're not going to get any traction for that kind of a statement.
I wanted to put that out to you that I am unprepared for this. I did not know that I had a statement to prepare, as everyone else did also, prior to being here.
Ma'am, you were provided the case law as you had requested at our last hearing.
I love the way she does the dog, the head tilt like a dog trying to understand English.
It was mailed to you. You asked for the case law that the court was making reference to. You specifically asked for it. That was provided to you. It was mailed to you.
Case law?
Yes, ma'am.
Case law? You know what? We're going to go back another half second here to check out the court clerk who is wearing the black sweater with the yellow top. She's just sitting on the left-hand side of the screen. She just has an open mouth stare at Sarah as Judge Kraynick's trying to explain how what's what and how many.
Provided to you. It was mailed to you.
Case law?
Yes, ma'am.
What was the date that it was mailed?
August 9. What was provided to you on August 9 was the additional copy of the pro se packet as provided by the Justice Administrative Commission. You were provided a hard copy of that in court, along with the case law that was referenced at the August 9 hearing that the court had said that it had reviewed in anticipation of the hearing that we were having this afternoon.
I don't have that. The only thing that I was provided was the notice of provision of witness list from the state, and then the JAC packet.
Those were both provided to you in court. You are correct. The balance of the things that I'm speaking about were mailed to you at the legal mail address on August 9.
Which I have yet to receive.
Which I have yet to receive.
Okay.
So, Luther Rose, I'm not sure if this was a planned hearing as much as the media made the motion to have cameras in the courtroom because Sarah had made the motion to leave them out. So the media responded to it. And this might have been one of those kick the bunk at 3 a.m. Hey, you got a hearing today. Hearings for Sarah. Not much you can do about it. There's advantages to having a lawyer.
Ma'am, with regard to
This is the first time I'm seeing each one of these documents.
I understand that.
I understand that. They were filed August 12th and unfortunately this morning due to an issue with the e-portal.
So there you go. So August 12th was the day that they were filed. August 13th, there was an e-portal issue, so they couldn't get uploaded. So even if Sarah did have internet in jail, she wouldn't have been able to receive this notice until, pretty last minute as it was. So the This is on the rocket docket now. The case is going to be heard, and things need to happen quickly. You can't just put everything off.
I wouldn't have internet access anyway to receive those.
They were sent to you via U.S. mail as well.
Yesterday?
Yes.
So she thinks that's a good thing to have on the record. So, sent by U.S. mail yesterday. Yeah, yesterday. Now it's today. Make your arguments. Go.
So
Thank you,
you're
are
not
in 2
wasting
months.
the court's time. You can feel free to review those at this time.
Quick shout out to Paul Clank, NYC. He's been digging up tons of the contemporaneous news articles on the Sarah Boone trial. So if you go to his channel, he's in the chat there, Paul Clank, NYC. You know what? I'm going to mod him up so he can also post his own channel if he wants in the chat. But yeah, he's pulled out a lot of original news footage of the Sarah Boone trial. So if you want to check out his channel, you can see some of those videos there. And what are
Is
these?
this the case law you're referring to?
Judge Kraynick can't see which paper she picked up, but I'm assuming so. And I think this is kind of where Sarah's getting the wrong impression that case law is just handed out. Like, why can't I have some case law? Everyone keeps throwing case law at me because you're on the wrong side of the law, Sarah.
State versus Smith?
I believe that those are the circuit court opinions that are referenced in WFTV's motion, which cite to the Miami Herald versus Lewis decision, which is the controlling law on this matter.
All of these are yours? And these are mine to take?
Welcome, Lanky Tour. Welcome to everyone who's here for the first time. I know not everybody comes into the chat, but I see we've got 47 viewers, which is a little bit more than we normally get on a Friday. So big dandy welcome from this fine and dandy chat to everyone who's here for the first time and enjoying the rewatch of this pro se Sarah hearing. Thank you for coming. And now we have another 5 minutes of her reading now that she's clarified or made it clear on the record that she hasn't had enough time. And this is where she's really milking it. I think the first time she piped up was basically her limit of understanding, like she's gleaned all she can from the paper in front of her. So now this is just milking it. This is just, well, you've put all eyes on me. I'm not going to tell you to stop watching me. Hey, Phil for Dom Russo throws out a big fuck you to everyone. If you're part of the Chelsea and Scott continuum of greetings, that's not how you greet people. It's not how you say, hey Scott, how you doing? Fuck you. But we say it here because we're all friends. We're all getting along. So throw out a fuck you to anyone that you're happy to see here in the chat. Lutheros makes a great point too. She reminds me of McKenzie, but McKenzie was 17, Sarah was 44. And I think that gets into some of this arrested development, and especially from alcohol abuse. It's one of the biggest things, as a parent, where you need to caution your kids. You've got the invulnerability of youth feeling, but if you're abusing your body while you're still growing, you're just as likely to put your body, your brain, whatever, into a state of arrested development where you don't grow. And Sarah totally seems like that type of person. She might have been a lot of fun to hang out with in high school, at house parties or bush parties and all that kind of stuff. But, her friends went on and started having lives, and Sarah just kept seeking the alcohol for satisfaction. And look at the path her life went down. And it's even dangerous for the McKenzie Shirillas, the young ones of the world too, because you'll make decisions that you think are in the moment or in the evening, and they affect your entire life and the lives of so many others. Well, look at Sarah using her free arms though. And somebody pointed out, look at the rolls on Sarah. Like, I'm not a big body shamer kind of guy. Like, my body's not perfect.
I'm ready whenever the court is. There's only so much that I can do.
Yeah, you're not ready. But for someone complaining about starving in jail, Sarah's body's got some, I don't know, ample proportions to it compared to pink shorts Sarah calling 911. I'm ready whenever the court is. There's only so much I can do.
Just not receiving these. Have any opportunity to look up any case law of my own meantime, so.
The opportunity to look up case law of her own. Sarah, you'll be so proud of the case law that you invent.
You can proceed, ma'am. What is it that you'd like to tell me about your concerns regarding the September 3rd evidence viewing that's been...
So just for the record here, September 3rd is the day that they've identified as the day that Sarah will get to see her discovery, as pointed out in the chat for the 9th time, because she's gotten her discovery every time she's had a lawyer, and then that lawyer's had to return the discovery, and the process goes on and on. So Sarah here complaining about, finally getting my discovery. Well, this would be the 9th time you're getting it at this point. Thank you, Charles Gree, for pointing out the exact number of discovery times she's had. So this September 3rd hearing she's arguing about, the funniest thing about it is Mr. J has a solution that he's just going to keep his mouth shut about until Sarah's exhausted all of her shenanigans. And then he's like, okay, well, here's another way we can do it. But he's not offering it to her at the beginning, which is point Mr. J.
previously scheduled.
My concerns is regarding my case and the whatever is left evidence that is not already on the internet or posted anywhere on social media. And I'm wondering what the reasons for the court other than sensationalism and exploitation. The purpose would be for them to watch me look at the remaining bit of my evidence that has...
I am a little sad that we didn't get to see that, because that would have been fun to watch her watching her own evidence in court and looking for something like, here's a Miranda violation. I'm going to rewind it a little bit. We're going to do our first Drunk Sarah audio. I'm going to reduce the speed of the audio to, where is the playback speed? And we'll to her whine at a more appropriate
or posted anywhere on social media. And I'm wondering what the reasons for the court other than sensationalism and exploitation. The purpose would be for them to watch me look at the remaining bit of my evidence that has not been globalized. Again, my main concern is it is for exploitation purposes, which has already been...
What are exploitation purposes? I understand the word exploitation, but what would be the exploitation purposes? Not exploitation, it's educational. Sarah, everyone who sees how stupid you are and how stupid your case is and how stupid your arguments are might think before they do something stupid. Educational, Sarah.
Greatly applied to my case in many, many ways, globally again.
Globally.
And I see on on the motion to intervene for WFTDs, my question is why...
Motion to intervene for WFTDs. Now, first time I heard that, I thought, what the fuck is a WFTD? Like a what the fuck to do? Or I think WFTD is just the name of the Florida radio station, and they've made their argument that they can film whatever the fuck they want.
Is this an important criminal proceeding? I don't. And what?
And that's kind of funny too. So I'm pausing a lot here, but Sarah's complaint now is she's turned it into, why is this an important criminal proceeding? So much of her argument is, this is the most important to me. All of these hearings are of utmost importance. And now she's trying to, I'm not even that important. Why are you following? This is like a jaywalking ticket. I've got the cameras in my face as soon as I get let go from the police station. What's going on here?
Why do they need to have it monitored?
Monitored. Sorry. Okay, we're going to let that play without because I think I paused it about 12 times in 15 seconds.
On the motion to intervene for WFTDs, my question is, why is this an important criminal proceeding? I don't. And why do they need to have it monitored?
Monitored.
I don't understand the reasons why just for this one. I'm not asking for all of my other hearings to be closed. Simply, this is my one and only. It is.
I almost expect her to break into Eminem here. Like, this is my one chance. My one chance to blow up.
My right to have some kind of privacy regarding my case. Nonetheless, it is an active case, and it's my understanding that
all cases before the court are active.
Some information is not able to be publicized due to privacy. And
I understand that some information is not able to be publicized due to privacy, but the fuck are you saying?
And it's not their right to pry and exaggerate, which is the whole point of why they want to be included in this one and only.
To pry and exaggerate. Now, from my understanding, they're just broadcasting what happens in the courtroom. They're not commenting on it. Like, sure, Law and Crime comments on it, but the raw feed is just the raw feed. There's no exaggeration.
Most important hearing that I would say that I have on the horizon. The press doesn't have a right to press.
Well done, Sarah. The press doesn't have a right to press into my life. Oh, you are such a wordsmith, Sarah. Look at the way you did that.
Themselves into everything in regards to my active criminal case, and I feel that from this, one meeting should be closed to the press so I can rightfully, lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet.
Exactly, Sarah. There is nothing. Everything in your case has been exposed because your discovery has already been given, and your discovery as a matter of the public record is public. So there's no Uno reverse card in the box. You just search for it and find it. You can secretly get it and then play it and at a proper time in the trial. It is what it is.
I'm trying to salvage whatever it is that I can.
California Dreamer.
To have a card to play.
Sorry to pause everything for California Dreamer, but I haven't seen California Dreamer since some of my earliest days of streaming. Welcome back, Tammy Sellin. Glad to see you here too. There's if you're wanting to chat, I've got subscriber mode on. You only need to be a subscriber for a couple of minutes before you're able to chat. If you're the type of person that doesn't want to subscribe but you do want to chat, you can subscribe and then disappear if you want to do that. I appreciate if you stay, but and a thank you to RN2 Moms. 5 gift memberships just got sent out. So Luther Rose, Faceted Dreamer, Carolyn, Just a Girl, Sharon Williams, and Eyes to See, you all just got free memberships to Dan D True Crime thanks to RN2 Moms. Check out your badges. Check out your custom emojis. I did add a new custom emoji, I think, too. So there's a couple of new ones. If you, I took out some of them that were a little too detailed to be seen small. So have fun with those. And let's see what these cards are that Sarah plans to play. Back to 15 seconds ago.
Lawfully do what I need to do in order to properly, rightfully, and lawfully defend myself. At this point, I feel that there's nothing even suppressible in my case that is not already on the internet and have been spread all on the internet. I'm trying to salvage whatever it is that I can possibly to have a card to play at least one in the end during my trial. I do not feel that it is right lawfully to have them included in this hearing, this one hearing, and I am asking for their admittance to be closed.
Okay.
This is an active, ongoing investigation.
It's not an active, ongoing investigation. The investigation was pretty much done 2 days after. There's probably a little bit more done, but 90% of the investigation was done by February 25th.
Case.
Hey, Mom of Lola's here. Deb
Anything else,
Richardson. A to B.
Your Honor.
No,
Steve,
Your Honor.
Do you have any position?
Sorry, I have to go back because that's a rare opportunity where Sarah is asked. Anything else?
Anything else, ma'am?
No, Your Honor.
State, do you have any position on Ms. Boone's closure motion?
No, Your Honor.
All right. Ms. Fugate?
Excuse me. Ms. Fugate is
Your Honor.
excellent lawyer here.
I think Ms. Boone's argument.
I think one thing that I'm impressed by with the way she gives this argument, and look at how Judge Kraynick gives her attention. Just because I've paused, he can't look away. But he is eyes to her argument, and she's making the argument. She's got her point form, so she's hitting on everything. But it's not this long-winded, meandering, quoting paper for long periods. She's given an effective argument, and Judge Kraynick is here to hear it. He's looking for any reason to deny this motion for Sarah, and seems thrilled that she's given him solid stuff here.
Really flips the question. It's not why the media wants to be there. What transpires in the courtrooms, even pretrial hearings, is public property, and there's a right to be there. I'm not going to go over the Lewis test because I know Your Honor knows it well, but it's a very strict standard, and it's the plaintiff's burden to meet. I haven't seen a case in Florida where a criminal case was closed on a defendant's privacy concerns. We're not talking about third-party privacy concerns or something that's not inherent in the proceeding. This is the evidence. And even with respect to the
Kevin
evidence
Brady.
and it being an active, still an active case, Florida law is clear that once discovery is provided to the defendant and accessible to the defendant, that becomes public record. That too becomes open to the public. So with respect to the first part of the analysis, I don't think the defendant has established that this hearing needs to be closed to protect her fair trial rights. Publicity isn't necessarily synonymous with prejudice. She has to show widespread, adverse, hostile.
Just going to break in quickly to catch up RN2 Mums who asked, who is she? I don't remember her. This is just a lawyer speaking for the media, arguing for the media's right to be at any particular aspect of the trial. And this is in particular the September 3rd evidence viewing. The reason you don't remember the September 3rd evidence viewing is because it doesn't happen. Mr. J has, like Sarah's asking for, a card to play. But Mr. J isn't playing that card yet. He's letting things play out before he gets to that card. But she's just the media lawyer. The thing that I found really interesting with this argument, watching it a second time or like rewatching it now, is I did the Betty Broderick marathon, and that was when Court TV had just started. That was her second big trial. And there was a part in the trial where one of the witnesses asked not to be shown on camera. And the follow-up witness was like, oh, she's not going to go on camera. I don't want to be on camera either. One was Betty's daughter, who'd already testified for an hour on camera. But the second was a jailhouse snitch who was like, well, she's not going on camera. I don't want to go on camera either. Anyway, the media lawyers were very unprepared for that. There was like a little kerfuffle in the courtroom. They actually had one lawyer on a dial-up phone trying to like listen to the courtroom, while a second lawyer that wasn't an expert in that but was able to at least. Anyway, that's how they argued through that, and the media lost. they were still able to record, but they weren't able to show faces. And it's a sign that 35 years later of how refined the media has gotten in arguing for their right to be at a trial, as opposed to when it initially happened. But her arguments are much stronger than the arguments we heard during a similar, not quite the same because it was about a specific witness, but basically about the media's right to be there in any case. And it shows the evolution of that argument.
Publicity, and then specifically show why that publicity is going to be aggravated by access to the September 3rd hearing. The discovery in this case has been public. I'm not sure what specifically would be aggravated by access to the hearing. So I don't think she's met that first burden under Lewis. And importantly, the admissibility of evidence, Ms. Boone said she didn't think there was anything suppressible, but even if there was, courts often suppress evidence but still allow access to the hearings and the evidence themselves. That's fairly routine. That alone, just the potential admissibility, that alone is not a sufficient reason under Lewis to close a hearing. And as Your Honor is aware, there's plenty of alternatives under the second factor to protect the defendant's fair trial rights. Careful questioning and jury selection can protect against publicity. The courts of this circuit have had their fair share and are well familiar with high-profile cases, and they are well equipped to insulate and protect juries from even prejudicial publicity. And finally, any closure would have to be effective and broader than necessary. Again, I'm not sure why the hearing would need to be closed, but I think even Ms. Boone has indicated it would be ineffective with what's already out there. And that was a consideration under Lewis.
There you go. What's the point of closing it if all the information's already out there? It'd be one thing if it was like some sensitive information, even if it was like, relevant to the trial, but maybe not a key factor, but, maybe a HIPAA violation type thing or, something like that. Still going to come out in the trial, maybe, even likely, but maybe no need for it to come out in pre-trial because it's, not out there yet. And, there's a possibility that it'll get settled before it goes to trial. In any case, that's not the case for Sarah's evidence. So, but, I'm belaboring the point. Judge Kraynick's very familiar with the Lewis rule.
If the information is out there, the discovery in this case has been public, there's no reason to close a hearing that's simply going to discuss things that have already been made public. I think heightened public attention only increases the need for transparency. Closure of judicial proceedings is a drastic remedy, and I don't believe the plaintiff has met her burden in this case, Your Honor.
Okay.
Unless you have any other questions.
I do not.
Thank you, Your Honor.
All right. Any closing remarks from you, Ms. Boone?
Yes, Your Honor.
Yes.
First, I'm only asking for this one hearing.
Right. This will be the last thing I ask for. I'm only asking for one thing. I don't know why you guys are so unreasonable. I asked for one thing, just one thing. I've never asked for anything ever before in my life, ever. You guys won't give this to me. Just one thing.
Which is a very important hearing. I believe
Now it's important. Well, if it's important, the media should be there, right?
that the press is simply in it for ratings and publicity.
I think you said that in your initial argument, but go ahead and repeat it because it was very effective.
My evidence is active, and I'm trying to salvage the little bit of anything that I have.
Salvage is something you do with a sinking ship. Sarah, you're correct. Your case is a sinking ship.
Pertaining to my evidence that is not available online, which would be in that hearing. And I also heard, she was speaking in regards to once discovery has been received, that is therefore public record. I just received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery to even have an opportunity to prepare.
And Charles Grieve, correction there. She just received her discovery for the 9th time. Or no. Oh, hold on. Just received her discovery to even have an opportunity. Hold on. Let me just go back a little bit. This is about getting her discovery. What is she saying? She just received her discovery. Oh, and this is where she gets it wrong. Once discovery has been received, that therefore is a public record. Right. Your discovery was received in 2020 with your first attorney. The attorney receives the discovery. Boom. Received. Public.
Received my discovery for the first time, and I'm still reviewing most, if not all of it. And I have not had the time to go through all of it, but I literally, on the record, just received my discovery.
She does not have the time to go through all of it, even though she's in jail and supposedly has endless amounts of.
To even have an opportunity to prepare to review any of that. And in regards to the hostile publicity, I have letters, I have messages, I have tablet information.
I have letters, I have messages, I have tablet information from around the world. Just like Pitbull, worldwide.
I have an entire folder dedicated to publicity in more than one way as being hostile, good, bad, ugly.
Remember that. She has a folder of all publicity, good, bad, ugly, hostile. The reason that becomes important is she starts itemizing all the shit she has in her fireproof bags. She talks about having 2 folders. She's wasting one of them on her publicity rather than her case.
It's publicity. This will incredibly enhance my inopportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking for all hearings to be...
That one I'll give Sarah, that's way better. Like, she really worked to... The press is trying to press themselves into my case. That one, that was labored literally in my case. That was pretty good, Sarah. Like that's how you use metaphor, analogy, simile, whichever one that is. That's how you do it. Return on that. We'll give you credit where credit is due. Even a broken clock is even a broken clock is right twice a day. And the same way, Sarah's grammar choices can be right by accident, I think.
An opportunity to have a fair trial because of the already millions of viewers that I have in my case, literally in my case. This would just contribute to it even greater. I'm not asking...
Because, yeah, we definitely were literally in her case. There was people, well, she might be referring to Tanika getting into her docket. But, yeah, there's people like both in her case, oh, what's going on? And actually literally in her case files. Tough luck, Sarah. That's what you get for doing crimes in Florida. Love the sunshine law. I'm walking on sunshine, yeah.
For all
Don't it feel
hearings
good?
to be
Ooh.
closed. I've not had an opportunity to review my discovery, which I just received. I have an entire folder and more information and letters and evidence in
One
regards
folder.
to publicity, hostile, any type of emotion that you can come up with. I have received.
Any type of emotion that you can come up with, I have received. I don't think that's true. I don't think she's received letters with pure love, affection, there's scammy ones, but not pure. So no, right off the bat, I came up with a couple.
From Australia being the most recent. So
Australia. Oh, gotta love Australia. Shout out to Australia. Australia, you keep pushing the UK. You are occasionally getting in there for third highest fans of Dan D True Crime. I see in those geography reports. So love the Australians. Yeah, I understand why Sarah's excited about having Australians care about her case. It's pretty impressive to me to have Australians give a shit about what I'm doing. So another one that I'm with you, Sarah. Doesn't happen often.
I do not believe just because they would like to, again, in my opinion, for ratings and for publicity. It's one hearing. There also is a solution that I believe, my understanding was that this could be held at the Orange County Sheriff's Department.
Stick a pin in that. Stick a pin in that. She's arguing it out. And yeah, why do you have that impression, Sarah?
The question was in regards to transport, which is a possibility. It was a matter of the decision being with the court.
Look at the judge just
I would
sitting there like
to
a
be able
photograph,
to
too.
properly prepare for this, would I have received everything prior as everyone else did? Having the internet would have helped also in regards to receiving the notice via email, as everyone else had. I'm sitting in front of you, yes, unhandcuffed, but I am unprepared for this rebuttal in regards for me to have privacy, expected privacy to a certain degree, and by law, to have this one.
I'll take a quick second here. The silence of the goats has broken the silence and spoken up in the chat. First time here. Hello, everyone, and good evening. Good evening to you. It's a morning for me here on the west coast of Canada, the North American continent, but maybe you're one of the Australian viewers that fan of Dan D and as far away as Sarah Boone's fans. In any case, welcome to the chat. It's fine and dandy here. We're glad to have you.
On hearing closed. And we also have an active case that is ongoing, active evidence, and there's a solution for it to be held at the Orange County Sheriff's Department as well.
Okay.
Okay.
Anything else from the state?
I wasn't going to bring it up until after the ruling on the motion, but
Mr. J wasn't going to bring it up until after the ruling on the motion. So it's funny because it seems like it's going to come out right here. This is 22 minutes into the video. I don't think he plays his card until about 40 minutes later.
the parties have reached an agreement to do this on our own. And as soon as that gets accomplished, if it's accomplished to both of our satisfaction, then I'll let the court know so you can free up the hearing time.
Okay, we'll address that momentarily. Ms. Fugate, anything else? All right. Under the Miami Herald versus Lewis case, ma'am.
So yeah, Mr. J is basically, you go ahead and make the ruling on this first. Then we'll talk about what I have.
Ms. Boone, you had the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary. What has been presented today has failed to meet that burden. Your motion to close the September 3rd viewing is denied. The court will follow up with a written order that you'll be hand delivered today. Ms. Fugate, if you don't have no longer any business before this court, you are free to go, ma'am. Thank you. Have a pleasant afternoon.
So just like that. Okay, well, Ms. Boone hasn't presented any evidence, so dismissing hers. You've won, Ms. Fugate. Is there anything else? And then that lawyer gets to leave. And now everything that we just spent the last 23 minutes of this video watching is going to be rendered mute by the next 5 to 10 minutes.
Mr. J, yes, ma'am.
Forgive me.
Forgive me.
When you stated to the court that my motion was oral, was this during the last hearing that we had?
You requested this both, ma'am, on August 5 and on August 9.
What was it specifically that I requested?
You had requested privacy with regard to the September 3rd hearing. And I advised you that I needed to look at the law on it. And you asked again on September 9th when we were going to address it. I said that we would address it on the 14th.
That was one slip by Kraynick. It was actually August 9th. But this is great because he's given all the receipts. And for anyone who's wondering where we are in the trial, this is exactly where we are. We're on August 14th. August 9th was the last Friday's show that we watched where she was shackled and argued to be unshackled. And here we are 5 days later. The media thing came in right at the last minute, and Sarah's still trying to argue, like, can I ask, what was the chain of events? What led to this meeting happening? I don't remember being informed.
You asked for copies of the law, and those were mailed to you on the 9th.
Which I have yet to receive. And I was not instructed by anyone in the court, including yourself, that that was an oral motion. If I needed to actually do a proper motion, I would have correctly done so.
That's why we had the hearing, ma'am, because you asked for it orally. So you orally moved or attendiously moved to have that motion heard. And we set it up for today, since we already had the hearing time carved out, to address you receiving the hard copies, which seemingly has already been remedied. And last week when we had our hearing on the 9th, I said I don't want to lose that hearing time because we already had it carved out. So we would proceed with the hearing on the privacy issue at that point in time. You then asked for the case law. I said, absolutely, I will get it to you. Mr. J had advised that he was familiar with the case law. But regardless, it was provided to all parties and mailed to you on the 9th.
Which I have yet to receive.
Which
and
I have
was not
yet to
instructed by
receive.
anyone in the court that that was an oral motion for me requesting privacy. I thought it was just a comment that I could have on record.
Ma'am,
I don't need to do anything further.
that's why we set the hearing, because it was something that you had asked for, and that's clear in the order that was provided to you on the 9th as well. It says that we would have a hearing today on the 14th.
And when did I receive this?
Well, that was orally told you on the 9th.
This is where Sarah, I think, picked up the oral motion for Judge Jackson. I think because this worked so well against her, she thought she could just, well, I made orally. No, the judge could say, I told you orally, because anything the judge says is automatically in order. But you can't just orally. Yeah, anyway. I think this is where Sarah thought that orally would work for her in the Judge Jackson case.
The letter itself was mailed to you on the 9th, but the order itself was read to you during the course of that hearing. Specifically, on August 14th, 2024, at 1:30 p.m., a hearing will be held in courtroom 12A, Orange County Courthouse, 425 North Orange Avenue, Orlando, Florida 32801, regarding defendant's review of the USB drum drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, delivered to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. That was all.
And a little heads up, the next video, we might watch it today. If enough people are into it, we can definitely do that as the next video. It is the September 3rd hearing, but it is not an evidence hearing. The September 3rd hearing is interesting for reasons all on its own, but the evidence gets seen before that September 3rd hearing that we'll be watching either later today or next Friday.
All addressed with you, ma'am, on August 9 here in open court.
In the order I have yet to receive.
But it was read to you, ma'am. It was read to you as to what we would be doing today, and that we would addressing the issue regarding the media's participation. And that's when you asked for the case law. And I said, I will give it to you. Absolutely. And it was all mailed to you on the 9th.
I'm not ever sure of what it is that I'm supposed to be doing with, I guess now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access to. So I'm guessing that...
Yeah, that sounds like another, we'll slow it down and listen to drunk Sarah. Playback speed, slow it down. All right, Sarah, let's listen to you whine.
Yes, now, oral and also in writing. And again, I'm sitting here waiting empty-handed for everything that was mailed to me day before yesterday and or could have been readily available on the internet, which I do not have access. So I'm guessing that your verbalization of the order that you read to me, which I have not received, is supposed to suffice.
Ma'am, you were told about the hearing in open court on Friday, August 9.
If I knew to be prepared, I know that everyone knows that I would be prepared, which I am unprepared because of.
Everyone knows I would be prepared, but I am unprepared because of. The hanging prepositions. It's the easiest way for me to imitate Sarah, and it also pisses me off the most when I hear finish sentences that way. Of which I am unprepared because of.
That's certainly your opinion that you're entitled to. Any reason for Ms. Fugate to remain? State? Okay.
From the state.
All right. Ms. Boone, any reason why counselor for the Orlando Sentinel and WFTV should remain?
No.
Okay. Thank you, ma'am.
No.
All right. In addition to what was set to be addressed today, which was the Ms. Boone's review of the USB jump drive, which contained the state's digital evidence, Ms. Boone's August 7th letter.
Bill Russo was asking about the award on the desk. That's a much better. Yeah, it's a glass microphone, but it's an award. It's not a real microphone, I don't think. No, it can't be a real microphone, right? He must have got it for being some sort of effective public speaker or something like that amongst judges. Good call for noticing. I've never even noticed that on the desk before either, but it's got to be something of, a point of pride for Mr. Kraynick to have it up on the desk. There's, it's not full of tchotchkes and, trolls and little pencil nubs and stuff like that.
Regarding her requests from the Orange County Jail. Mr. J, you made reference to a potential change in the September 3rd meeting. I want to hear about that, sir.
Here we go. So all of Sarah's whining, all of her complaining, this isn't fair, and, this is my one and only meeting. And then Mr. J, just like casually, the lifeguard throwing out a buoy to the passenger for the sinking ship.
I believe we have reached an alternative solution to an evidence view with the defendant. And as soon as that is accomplished to both parties' satisfaction, then I will notify the JA so that we can release your hearing time.
Okay.
I know it's valuable.
Can you explain to me what the proposed plan is for the viewing?
There will be a time and place where the evidence will be brought, the defendant will be brought, and she will be given as much opportunity to experience an evidence viewing like a defense attorney as possible. Her investigator will be there and allowed to take photographs and ask if he wants any particular bag of evidence opened so that it can be photographed, inspected, tested, copied as provided by 3220 in the criminal procedure rules. And then the evidence will be brought back to where it's stored, and then the defendant will be brought back to the Orange County Jail.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right.
So if Sarah had properly listened to Billy Lane, I imagine she would have already known coming into court today that none of the earlier stuff mattered, and that she could have just said, Your Honor, we don't need to discuss it because an alternative arrangement's been agreed to. But for whatever reason, she wanted to fight everything, well, if I'm acting as my own lawyer, I will fight every little thing right down to the last. This is already negotiated, decided. I'm going to go back about just 7-8 seconds to 12 seconds.
Okay. Have you had a conversation with Ms. Boone prior to today regarding this proposal?
Well, with Mr. Lane, who has indicated her position, which was that she agreed to that.
Okay. All right. Ma'am, I don't want to go into specifics of what you've had with your investigator, but has he relayed to you what Mr. J just advised the court of?
Yes, to a certain degree. It has not been fully explained because it is in the process of being.
Wow. What is going on? Oh, I got hair all over. There. Oh, what have I done? A big.
Spoken
There we
about
go.
between the two of them. So yes, I do know that is.
The way the sun is coming into the courtroom, it's lighting up all the hairs on her shoulder, all the stray ends and stuff. Like, sorry, I'm distracted. 29 and 36.
And fully explained because it is in the process of being spoken about between the two of them. So yes, I do know that is a solution to my request.
Okay. And did you understand what Mr. J advised the court of today regarding how that process for you viewing the physical evidence would be?
If you could please do so again.
Sure. If you could explain it again for Ms. Boone, Mr. J.
Please explain it again for the children. Explain it like I'm 5 years old. So, Mr. J, I think it was pretty clear. We all understood that, right? There's going to be an evidence viewing, everything the last 15, 20 minutes that you bullshitted about with the media and how important your case is, but it's not important, but it's super important, but it's not that important, but people from around the world are watching. None of that matters because we already came to a separate agreement. But I'll explain it again one more time like you're stupid. Here we go.
When a defense attorney wants to do an evidence view, you typically go to where the evidence is stored, depending on the law enforcement agency. He or she can bring an investigator, and an investigator may take photographs if so requested. We typically don't let the defense attorney manipulate the evidence him or herself. The CSI, who would be present as well, which is a crime scene investigator from the law enforcement agency, would be the person to manipulate the evidence on the cutting paper. And then you would have the opportunity to review, test, inspect each piece of evidence. So for instance, I'm not saying this is the evidence, but a piece of clothing, look at the front, look at the back, you could have the CSI turn it inside out, those sorts of things. And then it can be documented by an investigator with photography. Between each piece of evidence, there's a new piece of cutting paper, butcher paper laid down so that there's no contamination during DNA testing. And this is basically how the process goes on for physical evidence. If it gets opened, it'll get resealed by the CSI right there in front of all of us, and the CSI will reseal it with tape, re-put his or her initials over it with the new date, so everybody will be on the same date about why it was opened, when it was opened, so on and so forth.
Thank you for that. If I may, is it closed or is it open
If I may,
to?
No. People that are not involved with the case will not be there.
ba-ba-ba-bum. It's Sarah, who realizes that her life is doomed to be public now, just assume that wherever she goes becomes a public space. And it's like, no, it's the sheriff's office. The media doesn't get to go into the back rooms of the sheriff's office like they get to go into a public courtroom. I love how condescending Mr. J is with her. But also, like, it's olive branches. These are the kind of things that help keep her case from being appeal worthy. And yeah, it's all he can do. He's just, look, it's the least I can do. It's also the most I will do.
And if I may, if you know, will my phone physically be there?
If it is stored in physical evidence, then it can be brought over. We're not going to be turning it on. If it needs to be photographed or examined, it can be.
This is good too. So she's digging. She's trying to get into her phone, like literally into her phone. She doesn't want to look at the Cellbrite breakdown of her phone. She needs to get in to see her contacts. I think because she's too stupid to use the Cellbrite information to find her contact information. And yeah, she's just fighting for that access. And Mr. J shuts that down.
Physically examined, but in order for it to be turned on, it would have to be done at a different location where there's something called a Faraday box, or a room where electronic signals cannot come in or out.
Do I need to write a motion for that?
Can I have a motion for a Faraday box hearing?
For what? For your phone to be brought over and turned on?
If I can extract any type of information from it.
So
Again, all of the information has been extracted from your phone. You're just too stupid to access it. You need it to be packaged into software. And, you know, that's not a huge diss. I don't think I'd be able to break down a Cellbrite report super easy. I think I'd be able to, say, organize into file types and show me all the videos and show me all the text messages. Like, those might be two key things to have a look at. But, you know, I probably wouldn't know how to get all the app data and stuff like that. But yeah, that's not what she's asking for.
like we discussed in the last hearing, that would be up to you to hire a digital forensic examiner. And then we would make arrangements with that person so that he or she could image the phone in the same manner that it was imaged by law.
Thank you, I'm grateful.
Welcome.
Thank you. I'm grateful.
Then, ma'am, after having Mr. J explain that alternative solution to the evidence viewing, is that something that you would like to participate in?
Absolutely.
Okay, so then, is
Absolutely.
it the parties' agreement to no longer have the evidence viewing here in open court on September 3?
That's the state's position, but again, been doing this long enough to know that you can never predict every possible hiccup. But I will defer to the court if you want to free up your hearing time now or wait until we're able to tell you that we're satisfied.
Spoiler alert, you're going to need that September 3rd hearing.
Okay. Ms. Boone, are you in agreement with that alternative solution?
At the Orange County Sheriff's Department?
Wherever the viewing is going to take place. I don't know that a specific location was identified, but yes, where it's going to take place.
I am.
Okay, so then here's what we'll do. I will keep the hearing for now. The deadline to have that viewing as set forth in the August 5 scheduling order and notice of hearing will remain of September 3.
I'm going to pause this. Detective Wilbefit brings up Dan D. True Crime. It's an evidence. It's impossible for her to touch. And exactly, that's what Mr. J was kind of explaining was, you know, if you want to view this evidence, you can act like a real lawyer and, you know, you could come in and you could have your expert talk to my expert and, you know, ask for things to be opened. And we're not going to turn it on. If you want to do that, you need to hire an expert who will pay for a Faraday box and will go to there and, you know, do it in a way that doesn't affect the electronic data that is affected every time you turn on such a device.
If that evidence viewing takes place at a law enforcement agency based on the protocol as identified by Mr. J, I'll just need a notice that's provided, signed by Ms. Boone, signed by the state, signed by Investigator Lane, as to when it took place and how long the viewing was. And if that's provided to me, we'll then cancel the September 3rd hearing.
Yes, sir. We'll do that, and we can even list physical items that were brought. Indeed.
My only question about that is we had sealed at the last hearing the witness list and the exhibit list.
I think all the property receipts and all those sorts of things are already in the public record.
Okay.
I think there's a vast difference between a list of evidence that's already in the public record versus having them look at it with television cameras in the court.
Okay, all right, fine. Ma'am, are you amenable to that additional procedure that after the evidence viewing takes place, you would sign a notice reflecting when and how long that evidence viewing was?
Of course.
Okay, and then once that's provided to the court, it can be filed and then the court will cancel the September 3rd hearing. Yes, ma'am.
And that is done by the state?
The state will prepare it.
Documents and bring them.
Yes, ma'am, the state will prepare it. All you need to do is just review it and sign it.
Thank you.
Okay. All right, thank you, Mr. J, for providing an alternative solution. Ma'am, I wanted to go back and address your request for the freedom of movement motion that we addressed last week and your desire to use a Stuncuff. I understand.
My feed kind of froze. That's a good place to pause, too, because the Stuncuff hearing was hilarious. That was in the last meeting, or the last video we watched, and was basically her negotiating being able to move around the courtroom as her own lawyer and wearing a Stuncuff so that she, you know, could take a 50,000 volt charge. Wouldn't that have been great to watch? If she ever had to do pro se and like got too close to the judge's bench where the guy, sorry, I didn't know if you're going to jump the judge's box. I would have loved to have seen her take a Stuncuff to the leg, but.
That a representative from the public defender's office spoke to you about clothing and what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
That caught my attention when I was re-listening to this, preparing for the stream. As opposed to a skirt and pants? Who wears a skirt and pants? You wanted to come to trial wearing a skirt and pants? A skirt and pants.
And what they may be able to provide to you. Is there any preference with regard to clothing that you may have?
As opposed to a skirt and pants?
Correct.
Yes, I very much would prefer to wear a skirt.
Okay.
Yeah, well, as opposed to a skirt and pants, sure, a skirt. I'd have worn the pants, but do you have any pink shorts? I'd really like to wear pink shorts for my trial, my lucky pink shorts.
So if you wear a skirt, as explained to you by Officer Barnett, the Stuncuff is located on your calf Achilles area. It would be something that would be viewable by the jury. So do you understand that if you choose to wear a skirt for clothing purposes, that's going to be viewable by the jury?
I understand. My belief by you asking was that maybe it could be moved to a higher place where it cannot be seen, or is it strictly to the one area?
So think of that. It's an ankle cuff, kind of thing that's just going to send a shock through your body and put you to the floor. Sarah thinks it's worth negotiating wearing it high up on the leg, some sort of a thigh. I guess she might have been small enough for it, 5 years ago. Definitely at her, new wings meal and burger wings meals. She's, I don't think she's small enough to be able to wear an ankle cuff up near her thigh. We saw how short the skirt was that she wanted to wear, so think about where she wanted to wear that stun cuff.
Mr. Barnett, or Officer Barnett, explained at the last hearing how the stun cuff is affixed to a person. It is on the lower leg ankle area.
Okay.
Okay.
I'm not understanding why this is being...
Mr. Barnett, or Officer Barnett, explained...
Having some difficulties with this new spot that I'm broadcasting from. I've moved down from the true crime attic, which is quite hot. Take a look at the clerk, Judge Kraynick's clerk here. Normally she's quite busy doing her own thing, but she's taken time out to watch Sarah talk this stupid shit about wearing a stun cuff with a skirt rather than pants.
The last hearing, how the stun cuff is affixed to a person. It is on the lower leg ankle area.
Okay. I'm not understanding why this is being asked.
Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can and may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it. And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those, is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument.
Sorry, that was me trying to pause it again and waiting for the screen to come back alive. Okay, never mind. Did have something to say there, but we'll just let it play.
Any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Because I want to bring it to your attention that if you have a desire to wear clothing which would reveal the stun cuff, I want you to understand that it's something that the jury can't. That's
what I wanted to say. Judge Kraynick, super smart in saying you are making a knowing and intelligent decision. So this is him not wanting to give her legal advice, and quite the opposite, playing into, I'm not going to give you the clue that it's a stupid decision. I'm going to say intelligent and use it correctly. You're using your intellect to make a decision to wear a stun cuff that will be seen by the jury. That's your intelligent decision. And by saying intelligent decision, Sarah's like, yes, well, I am intelligent, so okay, that's my intelligent decision. So I think really clever use of language by Judge Kraynick to call it an intelligent decision on her part to avoid giving her the advice of, that's pretty fucking stupid. Can't give you advice, but that's pretty dumb.
And may be able to see.
I understand. Is it a decision I need to make today?
It's something that you need to consider. If you're wearing pants, they obviously cannot see it. If you're wearing a skirt, they can see it.
Actually, Your Honor, my intention is going to be to bring up the fact that I've been incarcerated the first time my lawyer, and I will be getting a lawyer, just so you know, my lawyer's going to ask me about my weight, and then I'll mention that it all happened since I was in prison and make all of this moot. So the first 20 minutes, moot because, they're not doing the evidence hearing in public. The last 20 minutes, moot because she gives away the fact that she's been in jail, regardless of her outfit. And even her first day outfit, what'd she pick? She picks a blue smock top, like a blue blazer top, basically looks like the same prison issue suit. We'll be seeing that in a few Fridays.
And you're making a intelligent, knowing decision that they can see that and that you want to proceed with wearing a skirt. Your other option, if you do not like either of those,
if you don't like,
is the parties will remain, you'll be hands-free, as we discussed, but you'll have the leg restraints like you have today, and everyone will conduct everything from counsel's table. All direct examinations and cross-examinations, any questioning of any witnesses, any argument, any opening remarks or closing arguments or opening statements will be made from counsel's table. You can certainly stand, but we will not have the opportunity to walk around the courtroom. Now, I know that we talked about in our last hearing that we would have another hearing when we have our trial case management in September, addressing the box as to where everybody would go to. And last week on the 9th, I said that we would limit access to from counsel's table to the podium, and we wouldn't be allowed to approach a witness or the jury, and those same restrictions would be placed on the state as well. Now, I'm not telling you what to do. I'm just giving you a series of options. Because if you want to wear a skirt, you have to understand that the jury can and will be able to see that device that's affixed to your leg.
And by my hearings that we have spoken about the Stuncuff, they are televised, correct?
To the best of my knowledge, the media has participated in the majority.
So this is again stupid Sarah. She thought maybe it might be a secret, the world wouldn't know that she's wearing a Stuncuff. It's like, no, we're just keeping that secret from your jury. That's it.
If not all of the hearings that this court has had with you.
Does the court broadcast live, or is it uploaded to the clerk of the court's website?
What is broadcasted live?
My hearings, in regards to all of them, basically, but recently the Stuncuff. Is there anyone that would know that I'm already wearing it if they could see it or not?
I can't speak to what everybody else knows.
So if I may, please, my options are pants, hiding the Stuncuff, or a skirt with it being visible, or I am able to sit here at the counsel's table with leg chains on, and no one is able to move except for here at the counsel's tables.
You certainly have the opportunity to stand, but we wouldn't be able to move around the courtroom, and those same restrictions would be placed upon the state.
Okay, I just wanted to confirm that those were my options.
Correct.
And when do I need to make that decision?
You don't have to make that decision today. It's something that we can address at the trial case management in September. Ms. Click, I see you raising your hand.
Your Honor, I just wanted to let you, so Ms. Boone is there fully.
Okay, Miss Glick is from the jail's wardrobe office. So I guess the public defender maintains clothes for prisoners to wear at jail. So she is sitting in the gallery directly behind Sarah. The reason I bring this up is Sarah doesn't turn around. She has freedom of movement. She's in a chair that doesn't move. It doesn't have wheels. But when she is talking to the woman behind her, she talks straight forward and just kind of turns her head a little bit, like so her voice goes to the side rather than addressing this person as a person and, fully turning her body around. So that's an interesting part about this exchange.
If you could, before you get to it, and just announce yourself for the record, please. Yes, ma'am, go ahead.
We have gone through the entire clothing closet as well as our backup for what we have. As it stands
Just pausing that to make sure that I've got her in frame on my studio view. Okay, yeah, you guys can see her. The woman in the pink skirt with the blazer that's standing and talking. And yeah, you'll just notice that Sarah does not turn around to address her. Makes the least I can do kind of motion of turning her head to project towards Mr. J. But
Right now, unless we have any donations to the size that happen to match that size, we have 8 pairs of pants, 3 skirts, and 1 dress, and that is every, we do have some shirts, but for in terms of skirts versus pants versus a dress, that is everything we have that would fit in this food size range. So I just wanted that to be aware so that if Ms. Boone is making any sort of decision, she understands the limitations in terms of what we have to be able to provide.
Okay. Ma'am, did you have the opportunity to hear what Ms. Glick said?
I did.
Do you have any questions for her?
If you could
so just in case you didn't hear what Miss Glick said, basically it was just about how they would get stuff to her and what stuff they have the opportunity to provide. So probably in accordance to, you're wearing a Stuncuff, we have 3 pairs of pants that would cover it. If you're not wearing a Stuncuff, we have 2 skirts that you can also choose from.
please repeat what it is that you all have available, the numbers?
But yeah, did you see how she turned to her or didn't turn to her? Go back just slightly. 28.
Okay. Ma'am, did you have the opportunity to hear what Ms. Glick said?
I did.
Do you have any questions for her?
If you could please repeat what it is that you all have available, the numbers?
8 pairs of pants, 3 skirts, 1 dress.
8 pairs of pants, 3 skirts, 1 dress.
Ma'am, do you have any other questions for Ms. Glick regarding the clothing that the public defender is endeavoring to provide for you?
And if I do come to the decision, I can't always have someone externally bring something into me.
Absolutely, you can always.
Jiminy Glick's a great interviewer.
Your personal property at the visitation center, which I described as across the street from the Wilson Center. That is not, the public defender's office is in no way involved with that. It was put in your property and the corrections with transport of property.
Just again, if you didn't hear, it's basic how they get the clothes from the office to the court, and that's it. I'm going to try refreshing this page. Hopefully that doesn't cause a bigger problem.
You come to the decision, I can't always have someone externally bring something into me.
I could also have someone externally bring something into me. That was what she was asking about. It's good that we had that slowed down there. And this ends up becoming James Owens and the girls bringing in equipment. And she's asking, can we use the same transport method that would get me clothes from you? Can I get my clothes to you guys so that they can bring them to me?
Always have someone provide something in your personal property at the visitation center, which I described as across the street from the Wilson Center. That is not, the public defender's office is in no way involved with that. It was put in your property and the corrections with transport of property.
So somebody can put stuff into her property, and then that's her property. That could be transported to the court by corrections, but not by the defender's office.
Yes, ma'am, thank you.
All right. Any other questions for her?
And yes, this is immediately before Owens. I think we'll be sticking around today. The next video is where James Owens makes his first appearance. And if nothing else, the very beginning is a lot of fun watching the pure joy on Sarah's face as she comes in with her successful outcome to her circus ad. But yeah, ask for place a circus ad for a lawyer, get a circus clown for an attorney, and
All right. Can Ms. Glick be excused?
Yes, thank you.
Thank you, ma'am. The next issue that I wanted to address was the review of the
Go back a half second there. Look at who else is in the courtroom. Billy Lane is there. Don't know who anyone else is. There was somebody here on another matter on one of the 2 days that I was looking at video too. So possible they're just
next issue that I wanted to address
waiting.
Was the review of the digital discovery. Ma'am, Mr. Lane was provided at our last hearing on the 9th the hard copies of the discovery, the USB jump drive, which contained the state's digital evidence.
This is getting into the third part of the trial now. This is the Billy Lane part, the discovery, the jump drives, the evidence. This is where Mr. Chevendell makes his appearance. I think it's Chevendell. Mr. Chevendell is the attorney for the jail. And Mr. Chevendell came to this hearing with no fucks to give for Sarah and immediately shows that he's all out of fucks right from the start.
And digital transcripts of the depositions of detectives Chelsea Copsell and Scott Lowen. And he was to meet with you on Saturday at 9 o'clock.
Carolina, we'll be
Did that
glad to see
meeting
you
take
later.
place?
It did.
Okay, what was provided to you, if anything, at that meeting?
What he and I
Lakeisha, good to see you.
What was provided to you?
This is perfect too. So Judge Kraynick is trying to get on the record that majority of the discovery is on digital files and provided to her. But she's like, provided to me? I don't think anything was provided to me. When I think of people providing for me, I'm thinking of, hot meals and wings, not my evidence. It's my discovery already. Was it provided to me? Is that what you mean?
What was given to you by Investigator Lane?
The digital evidence we went over, and we're still reviewing the discovery, but I don't recall anything physically being handed to me.
Okay, all right.
Okay.
And when you say that you went over the digital evidence, are you referring to the USB drive with the 9 items that were identified in the state's exhibit list?
Yes, I do have that. We have not concluded going through that. We have other meetings tentatively scheduled, which we will be concluding that also in order to meet the deadline for the objections of the 23rd of August.
How many?
The deadlines of the 23rd of August is basically at the August 9th hearing where the digital evidence was provided to her. If she wanted to object to any of the evidence that's coming into the trial, she had 2 weeks to do so. So she has to file that motion by the 23rd.
How many of those 9 items were you able to review with Mr. Lane on Saturday?
Quick guess in the chat. So there was 9 items. Now, of course, a lot of you have seen this before, but some of you haven't. So you can put a number from 1 to 9, or 0 to 9. Of her 9 items of digital discovery, how many do you think her and Billy Lane reviewed at their first opportunity to do so? If you've been watching along, you'll know that she's wanted this discovery. She doesn't understand why she's not getting it sooner. Why can't it be here now? Why can't it be here yesterday? Just give Sarah a chance to say her answer very quickly. So once again, number from 0 to 9, how many items of her digital discovery did she have an opportunity to open and review once it was provided?
Not more than 1.
Not more than 1. Not more than 1. So you had 9 pieces. You had a chance to meet with your investigator, Billy Lane, looking fantastic in his tailored suits as always. Not more than 1. What numbers are there that are not more than 1? There is 0 and there is 1.
Lane on Saturday.
Not more than 1.
Okay.
Okay.
Were you able to access all of the 9 items on that USB drive?
For the brief moment that he and I were able to attempt to do so, yes, they seem to work.
Okay.
For the brief moment that him and I were able to attempt to do so, they seem to work. Of course, I didn't really care about getting any of this because all that stuff makes me look guilty as fuck, so didn't want to really see the evidence, but it was my right to have it. Now that we have it, we're able to move on to other things. Harassing Brian.
You did not have any issues opening up any of those files?
I personally myself did not open all of them.
I personally myself did not open all of them. No, you don't care. Kelya brings up that she needed time to flirt, and yeah, there's some evidence, there's at least speculation, maybe not evidence, but speculation that she was saving up her staples from previous legal documents in order to make her uniform more tight-fitting, but it looks like she's accomplishing that all on her own. I don't see Staples doing the work here. This looks like that's her body filling out that jail outfit. Could you imagine what kind of staples would you be putting in that to make it tighter? Like, maybe it's for the pants.
Okay. All right. Okay.
It's on our to-do list.
It's on our to-do list. Yeah.
Ma'am, Mr. Lane also took possession of the hard copies. Have those been provided to you?
They have. They were waiting at the dorm for me upon my return of the last hearing.
Okay. And where are they currently?
They're located at my bunk area.
Okay.
Okay, that's a bit of a problem. Because this whole time we've been told that she can't have the boxes. That's why they were going to put them on digital. Judge Kraynick wanted to get this on the record, and this will be part of the next hour of the video here, is a little discussion over why do you have those paper documents, who said you could have them, and what are we going to do because you can't have them.
And what are they stored, or how are they stored?
The hard copies you're referring to?
Yes, ma'am.
The 2 boxes are at my bunk on the side in between other bunks.
Okay. All right. Are they in?
Big hello. We have 100 live chatters. The last time I've had 100 people in a chat was when I was reading the supplemental final judgment. So a big welcome and thank you to everybody who's here for the first time to Dan D True Crime. Everyone who's here again after a long time, welcome aboard. It's a fine and dandy chat crew. We really appreciate your company and thank you for coming in. We'll be going live for at least another hour today, and if the attention remains what it is, we're going to stay through for the James Owens hearing. That's about an hour more of video. So we've got 2 hours of video, which means probably 3 hours of video and commentary. So sit right down, put your feet up, grab a medical cigarette and a medical snack, and hang out. We're glad to have you.
Type of bag, or is it just the 2 boxes that are right there?
Just the 2 boxes.
Okay. All right.
And immediately we drop to 99.
You've told me that you live in the female dormitory with limited privacy. You understand by keeping those boxes there may be a risk as to other persons looking at them.
I understand.
I don't have any other choice.
You do,
But
though.
you understand that
You do have another choice. You could have respected the digital evidence procedure that would have secured your belongings. She's more concerned about the guards leaking her digital evidence online, and that is like the source of YouTube videos, without realizing that all that evidence is already out there. There's no need for a guard to be sneaking her digital evidence out of the lockbox, to get a special post on YouTube. Suitcase videos out there, that's the one that's putting you away. The other videos, they were bad too, but it wasn't going to ruin your case if somebody saw the video of George saying today was going to be a good day. That wasn't going to prejudice your case worse than the suitcase video. But yeah, she's so concerned about the jail staff that she's being completely naive about her fellow prisoners. Who wouldn't be going through that? If you were in jail with someone, the suitcase murderer, Wouldn't you want to be picking through her evidence files when she's not around? Like, so stupid, so dumb.
Risk exists.
Of course.
Okay, do you understand that there's a risk that those items could disappear?
I understand.
Okay, all right.
Okay, all right.
And do you understand that it's your request and choice to keep those documents in your possession?
I do, and I'm
So these are all, again, Judge Kraynick. You can't give advice to a pro se client, or, you know, someone who's representing themselves pro se. But all these questions, if you had the modicum of perception and, you know, reading between the lines, you'd realize that each one of these questions are like, you realize this is a stupid thing to do. But he's phrasing it as, okay, and you understand that this? Yes, I understand, Your Honor.
also requesting in my letter to the captain and to the major to also be able to store all of the USB drives and the hard drive in my locked drawer, also for an extra security measure.
She wants the digital evidence in her locked drawer for an extra security measure. You're in jail with presumably people who have the ability to pick locks. And I'm sure the locks that are available to you inside the jail as an inmate are not super robust. There's a channel, I haven't watched it in a while, but it's called Lockpicking Lawyer. Kind of cool. It's just it's a top-down view of his hands working locks, and it kind of shows you how easy most locks are to open if you're an experienced lock picker. So the idea of having your things locked as an extra layer of security within a dormitory prison is the stupidest thing. Well, not the stupidest thing she said, but you know, it's in that top 15, 20% territory anyway.
Okay, all right. I see that we'd have Investigator Lane here. Sir, if you could come up. Madam Clerk's going to go ahead and swear you in.
Mr. Lane, looking good.
I do.
Sir, good afternoon. Could you state your name for the record and your affiliation with Prison Break Investigations?
Barbara
Billy
King,
Lane,
welcome.
Owner and Chief Investigator of Prison Break Investigations.
All right, thank you, sir. I did see that your notice that you provided regarding the distribution or providing the discovery. You provided the hard copies and the USB with the digital and the USB with the depositions of the two detectives.
That's correct.
Okay, all right, sir. And when you met with Ms. Boone on Saturday, again, I don't want to go into any specifics, but were there any issues accessing any of those USB drives or any of the files?
Not at the progression in which we made through the files.
Okay,
If there is, I will be happy to let you know.
all right, very good. But as of right now, there's been no issues as to access from what you've reviewed? Okay, all right. State, do you have any questions for Mr. Lane?
No, Your Honor.
All right, ma'am, do you have any additional questions for Mr. Lane?
In regards to the drives,
Correct, based on what was teed up for hearing today, which was addressing your review of the USB jump drive, which contains the state's digital evidence.
Mr. Lane, are you able to briefly meet with me downstairs after this concludes?
I'm not
Probably
sure
not.
if that's permissible with the policies and procedures. If not, I'm going to try and schedule a meeting with you.
Okay.
Any other questions for him, ma'am?
No, Your Honor.
All right, can he be released?
Yes.
All right, state.
Yes, Your Honor.
Thank you, sir, appreciate you. Okay. The next, ma'am, is your letter from August 7th to Captain DiGiovanni, which is the court has had the opportunity to read. I believe that we have a representative from the Orange County Jail who's appearing virtually. If you could please unmute yourself and turn on your camera, whoever it is that may be appearing from the Orange County Jail. I have a Administrative Sergeant De Jesus.
Yeah, all right. This is going to get good now. Well, it's been good. It's going to stay good.
Good afternoon, Judge. This is Captain Gina DiGiovanni. with Orange County Corrections. I'm the captain of the Female Detention Center. And yes, I have Administrative Sergeant Stephanie DeJesus with me.
All right, very good.
I will also want to make it clear that I have Orange County Corrections Department Legal Counsel Scott Chevenel on the phone with me.
Okay, very good. If all of you can, if the Captain DiGiovanni and Sergeant DeJesus, if you could please, I only see you, Captain. If Sergeant DeJesus can come into frame, we'll have Madam Clerk swear you in. If you both can raise your right hands.
Yes, ma'am. I do.
All right. Could you both state your names for the record for me again?
Administrative Sergeant Stephanie DeJesus.
Captain Gina DiGiovanni, Security Operations, Female Detention Center, Phoenix Facility, Genesis Facility.
And can I get appearances for legal counsel for the Department of Corrections, please?
Scott Chevenel, County Attorney's Office, representing the Department of Corrections.
Okay. All right. Very good. Captain, have you had the opportunity to review Ms. Boone's August 7th letter regarding some of the requests that she has in this case?
Yes, and if it's okay with you, Judge, I'd like to address each request one by one. Do you have a copy of the letter?
I do, and we can proceed with the 7 different items that she has requested. So if you
Actually, so with number 1, the request to have her review time extended, I can make the extension in the following fashion. We'd still have to collect the laptop at 4 p.m.
This is, I think, pretty smart by the jail Captain Giovanni, addressing the points one by one rather than as a group, because some of her requests are reasonable and some of them are outlandishly ridiculous. So the one by one allows, rulings on each thing, or at least keeping them organized, because Sarah's requests are all over the map here. And also by opening with the first one where she's able to, I think, be a little generous, like Sarah asked for, 10 hours rather than the 8 she was given. And the captain comes up with a plan that's going to give her, maybe 12 hours of access, but she still has to turn it in at the shift change. So it works for the jail, but it still ostensibly works for Sarah if she gave a shit about going through her materials instead of just giving people shit for not getting her materials.
This gives the staff and supervisors the ability to conduct the afternoon head count, conduct the meal dinner service, conduct the shift change, and then the evening head count. I am willing to allow her Sunday through Thursday to get the laptop and the USB drives from 8 p.m. to 10 p.m. and Friday night and Saturday night from 8 p.m. to 11 p.m. That is more than the requested time that she has asked for additional viewing.
Ma'am, do you understand the extension that's being provided by the Orange County Jail regarding the laptop, that on Sundays through Thursdays, additional time from 8 p.m. to 10 p.m., and Fridays and Saturdays, 8 p.m. to 11 p.m.?
Correct, with them collecting it at the normal 4 p.m. time.
Correct.
Yes,
All right. Do you have any questions regarding that extension?
I do not.
Okay. Is that acceptable?
Very much.
All right. Moving to the next issue, Captain, the USB drive security.
Number 2, USB drives. It's a matter of security. The metal tips, the drive itself can be fashioned into something other than what it's originally intended for. These items are secured in a secure control room and inventoried by our supervisors on every single shift. They're also inventoried and acknowledged being in good working order and repair by my DSTs, the escorting officer, and my supervisors.
Sarah scoffs at the idea of a USB drive being fashioned into a weapon. And the weapon is just one of many things that a piece of metal can be used for in a prison. I'm just showing the top of a lighter here. Obviously can't have a lighter, but even just this little piece on top would be about the same amount of metal that you could get maybe from a USB drive. If you're making jailhouse weapons, like, you know, the old movies in the 90s showed them with the hard plastic toothbrush, you would heat that up enough to get a piece of metal in there so that it's affixed, and then, you know, once that melts back together again, you sharpen the metal over and over, and you've got yourself, you know, a pen knife that might work for, you know, anywhere from, you know, 20 to 30 stab wounds before it breaks. So it's a real thing. People in jail have nothing but time, and the jail captains have seen everything before. So Sarah scoffing at, other than possibly being made into a weapon, is there any other reason I can't have them at my bunk? It's like, that's way enough of a reason. Like, you know, there could be other reasons, but that on its own is a fantastic reason that you can't have it. No.
So there's, at this point, unless directed by legal counsel or consultation with legal counsel, I believe that these drives are secure and managed. This, by the way, is the same way it's managed by other facility captains, that you get a viewing period and then everything gets secured and inventoried.
Ma'am, do you have any questions with regard to the USB drive request in your letter and the position of corrections regarding it being a matter of security, and how the USB drives are secured, controlled, inventoried, and confirmed to be in good working order?
I understand the process. My only concern is if I'm able to have my hard copy of 2 full boxes of my discovery, I'm not sure why.
You're not able to have your hard copy of 2 full boxes of your discovery, but more on that later, Sarah.
Other than the fact that the assumption could be made that it could be made into something other than a USB drive.
You all are trying to assume that it would be made into something other than a USB drive? I think you all are trying to assume that.
And I'm trying to avoid any further leaks of information that could possibly be suppressed or utilized in my case. So I didn't know.
Hey, Devs
if
for
I could have my
Dummies.
hard copies, I'm unclear, other than those reasons why I cannot have those as well.
To the extent you're able to answer that question, Captain.
And I would just chip in that, you know, obviously.
All right, that's Scott Shevendell chipping in. Scott Shevendell is the jail lawyer. We'll give it a second for people to return to their computers, because this is the first of many great interactions from Scott. Elizabeth reminds us, this is Elizabeth 3236, I seem to remember that Tanika's 2 cents got inmate contact forms, and that Sarah never got the laptop in the evening, and there were days she only had it for a couple of hours or not at all. And that's that tracks. She would rather argue for her right to have the laptop than she would use the time to use the laptop effectively. And the only thing she really wanted the laptop for, I think, was so that she could use it to trade favors within the jail. Like, hey, I have a laptop. I can get you that message sent out, or I can do XYZ if you do XYZ for me. And yeah, that wasn't realized because the jail's smarter than you, Sarah. A lot of people are smarter than you. Another person who's smarter than you is Mr. Scott Shevendell.
See the safety issues, and you can definitely distinguish between, you know, paper copies and anything made out of metal, which is what the captain just testified to. That's the problem. It sounds like to me is anything that could be a safety hazard is an issue for us.
So, ma'am, do you have any other questions regarding the Corrections Department position with regard to the USB drives?
What was the outcome?
It sounds like unless I've missed something, it sounds like the Orange County Jail is going to continue with their protocol of.
What was the outcome? You won, Sarah. I ruled in your favor. Did you not notice that? You must have missed it while you were ruminating on what you were going to ask. What was the outcome?
Inventorying, and keeping the USB drives in accordance with the procedure as provided to you and read to you in open court.
And Judge Kraynick summarizes, the outcome is they're not going to do it. They're going to follow their policies. Does that sound familiar to you? Do you remember? You were sitting here when it happened, Sarah.
And that's due to metal?
That's due to the reasons that were already identified. The matter of security regarding the drive being fashioned in a way that may affect security.
And that's another point. So they're not just saying, no, not just as a weapon, fashioned into something that isn't the USB drive anymore. So it could be for anything for, say an inmate's trying to copy a key and they take an impression of a key using a piece of gum. You can now use that piece of metal, shape it to fit the contours of your, all sorts of different ingenious little things that you can do with a flexible piece of thin metal. So, Sarah, just because you're too dumb to figure out what it could be used for, the other prisoners are very capable of using it in a way that could affect the security.
And it continues to ensure that those drives are secured, controlled, inventoried, and in good working order. Do you have any questions?
Could you please provide the last name of Scott, the legal counselor, please?
This is great, too. So she asks for the last name and takes the time to spell it. You watch her write it down on the thing. So let's, and I'll correct my spelling. I think I'm right as Scott Chevenel, but it might be Chevendell. We'll see.
I'll spell that, Judge. Shevenell.
Okay, so I've got it correct on screen. It is Scott Chevenel. Chevenel. Remember that. Chev N L. And she's writing it down, so there's no reason she should get this wrong.
One more time, please.
Shevenell.
She asked for it with the same energy as people who are getting arrested on body cam for DUIs. Like, badge number, name and badge number. Because they know it's the one thing that police have to provide for her. So in order to try and, take that narcissist control of the situation, she's asking for spellings of names. And Mr. J, and how is that spelled? Jay, thank you.
Thank you.
With regard to the third request is to a classroom, Captain DiGiovanni.
So that classroom is a multi-purpose classroom. It's used by programs and chaplain services. I cannot allow the use of a classroom. What I can offer is if the defendant is willing, I can move her to a housing unit and place her in a secure cell where no one will disturb her and she can.
This is really good, too. This is where Captain Giovanni does her Rick from Pawn Stars. I know what you're asking for. Can't do that, but what I can do is put you in your own cell, away from the big bay. You'd have all the time that you say you want to go over your files. You wouldn't be disturbed. It's really the ideal situation for somebody saying what you're saying if they weren't lying. But you're not lying, so... Isn't that a great offer? Isn't that a great offer, Sarah?
Review and conduct case review. She will still have access to a shower. She will still have access to open day room time. She will still have access to phones, but the review and her location will be in a secured housing location where she would be the only person in the cell.
And now Sarah trying to show off her, she's been in the jail for a while, so she knows the dorms. So she's not going to call it K dorm and L dorm. That's Kilo dorm and Lima dorm.
Ms. Boone?
Captain, is this Lima dorm?
K dorm.
Kilo.
Has to correct her. Kilo. Because I'm sure it's what they say in the prison, but just needs to correct even at things that, really don't need correcting just to show that she knows something. Oh, Kilo. Isn't that the former maximum security unit?
So my only options are being moved to the maximum security dorm or my bunk.
K dorm is no longer a maximum security. It's a multi-purpose area with inmates of varying needs being secured and housed there.
So it has, all the accoutrement of a maximum security wing, meaning locking doors and secure housing units. It would seem like an ideal situation. Like if I was in prison for something I didn't do and I wanted to review my documents, it would be a godsend to have my own room where I could just sit in there, even after hours, 2 a.m., wake up, work on my little documents and, try and find nuggets of information in the discovery that are going to help me. She doesn't want to do any of that, though. She has her comforts in the Big Bay.
So it is not the maximum dorm any longer.
That's correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire?
While it's dark the entire... You can say day. You don't have to just end it at entire.
That's correct.
I do love the way that Captain T. Giovanni, if you don't need to use 100 words, use 2. That's correct.
Correct.
And I'm unable to utilize the classroom for an hour or two per day while it's dark the entire?
That's correct.
And if I may ask, other than it being accessed on a rare occasion
Page or 3.
the 2 classes that do participate in that classroom, why is it that I'm unable to sit and be viewed by the officers at all times in my dorm comfortably to be able to utilize the phones on a regular basis, the day room on a regular basis, to be able to go outside to recreation, to have just for fresh air? How is that? I'm not understanding.
You're not understanding how to act as your own best advocate. So all of those things is Sarah trying to testify when she should be asking questions. If she really wanted to follow this line of argument, she would say, Captain D. Giovanni, isn't it true that for fresh air, people in the Big Bay get let out for an hour a day? Isn't it true that in the secure housing units, you only have access to XYZ? You can ask questions to get this info on the record, but Sarah needs to pontificate on all the things that she knows and then ends up just leading herself down like a dead end where she doesn't have a question at the end of it all.
Specifically why the reason is it has to be so extreme from going to being locked behind a door 24 hours a day to not being able to just utilize the classroom for an hour or two per day.
Nobody's using the classroom that's for all 400 jails at certain points of the day, so I'd like it all for me.
Ma'am, you will still retain your rights as an inmate and have access to all the services and day room time that you currently have during the same operational hours. And instead of having to move items from a housing area into a classroom where the officer may have line of sight, I cannot guarantee that my officer will have continuous unfettered access to you to ensure the safety and security.
Bettered. That word comes up a lot. Unfettered access. I'm going to look up in the background, but we all know what unfettered means. Do we ever hear that word without the prefix? I'd like to have fettered access to this and fettered access to this. Or, you can imagine in prison that all your access to everything is going to be fettered, right? I'm going to look up fettered on my own time here.
Security of that classroom while something may potentially occur in the housing unit. So as a matter of security to the rest of the inmates in the housing unit that you are currently assigned, my staff, and the facility, I can make the accommodation where I could put you in a single person cell.
Repeat yourself. Yeah, make it clear for her because she needs it told to her twice with simple words. Fettered means restrained, restricted, or bound, often in a way that prevents free movement or progress. It describes someone or something weighed down by literal chains or metaphorical limits. Fettered. Sarah Boone is fettered.
Where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I love how they're making a point of like, and for God's sake, shower, Sarah. We're giving you every opportunity to shower. Please take the opportunity to shower. Whatever we do to move you around, you can still shower, Sarah, please. For the love of God, shower.
I've been in a situation where I have been behind the closed doors also when I was made PC, when I first got to...
We're going to go drunk Sarah for this because this is a little whiny diatribe that should be listened to in her drunk voice. Oh, I was made PC.
Area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
Okay, why won't this work for you, Sarah? Please tell us how this would be, something that you wouldn't like. So...
I've been in a situation where I have been behind the closed doors also when I was made PC when I first...
PC is protective custody. Protective custody is where a lot of inmates spend their first days because they're worried about both harming themselves or danger to them from other people in the prison. Sarah made a big point of saying how she was in danger from the Torres family, so probably threw herself into protective custody because of those complaints and concerns of hers going into the Big Bay.
got to County Corrections Department, and if it's anything like that, I do not ever want to have that experience again.
Unfortunately, you will have that experience for life. For life. Life in a Florida prison. That said, she's still in the Big Bay. She's still requesting the Big Bays, right? She's in the annex, which is the Big Bay of Lowell. Lowell, you're in Lowell. But yeah, if it's anything like that, I do not ever want to have that experience again. Sarah, you're in court for locking someone in a fucking suitcase, and you're complaining about being locked behind a closed door. George would have loved to have a room with a closed door, Sarah.
And to be honest with you...
Oh, please, be honest. Be honest, Sarah.
Forgive me, Captain.
Forgive
but
me.
I do not believe that it would be this simplified, and nonetheless, I'm behind a closed door.
I don't think it would be simplified, and nonetheless, I'm behind a closed door.
For 24 hours.
No, everyone's at least 23 and 1. And it's that the door is closed to secure your belongings better than your stupid fucking drawer that you were going to put the USBs in to protect them from the jail guards.
Is there anything that I can do? Any kind of research research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm.
Yeah, some research will help you with that, Sarah. There's some research you can do so that you can do this. You can secure your general population dorm. Is there any research?
Where I do have friends.
Friends?
I do have...
Friends? What kind of way is that to live? Ugh. Friends? It's no way to live, man. Comforts.
Some type of comfort there.
What kind of comfort do you think Sarah's getting there? You get some kind of comfort there.
In order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours.
We're in real time now because there's no question. Captain. Captain, I'd like an answer to my long rambling diatribe that really had no question. Captain?
Comfort there, in order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours. Captain?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this broad, general question about alternatives.
The objection is sustained.
What does sustain mean, Your Honor? This is when Sarah still doesn't know what sustain means.
In regard,
She was just kind of waiting. Hello to Bedtime Lullabies, who's driving but listening. I hope you're enjoying this as much as we are. We're having a great time here. Scott Chevenel, please continue.
to number 4, earphones or headphones.
Bad
I would
idea.
need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel and my chain of command to get
that little do I think was a phone that was in the testifying room that Scott Chevenel and Captain Giovanni are in. But we're taking a pause to thank Bedtime Lullabies, who has given 5 Dan D True Crime memberships to Angel for Manny, Melody Hatfield, Allison Dolly Lama. I love that name, Allison Dolly Lama, the Dolly Lama. Beth Serrano and Kel X82, you've all received gift memberships from Bedtime Lullabies JLC, who's driving in their car and listening to us enjoy ourselves. Thank you. Thank you so much.
guidance on that. Regarding number 6, a word program.
Sarah can't use the Notes app. She needs, headlines and fonts and the whole word processor program.
We've not had a pro se inmate, again, myself, that requested access to a Word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we could make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited.
Okay, so this is good too. Captain Di Giovanni is reading Sarah, so I'm going to slow her down not quite as much to about 40%. And it's funny that just slowing down someone reading Sarah makes them sound so much more like Sarah. So let's...
Pro se inmate, again, myself, that requested access to a Word program. I would need to consult counsel, legal counsel, and my chain of command for guidance before we could make a response. Number 7, telephone access. In her statement here, as you are aware, my dorm contains payphones only and are limited to only 15 minutes per call, which are collect. I need to be able to communicate on a regular, normal phone.
Unfettered.
To make all necessary calls.
I really love this Sarah impression by Captain Di Giovanni here.
I'm turning the page.
Hey, Jane Crow, welcome to the fine and dandy crew. I'm turning the page.
For my case, to use in trial, I have no other way to contact anyone that is not collect, which incredibly, I believe that diminishes.
Little shade on her handwriting.
I don't know what the other word is here. If not all of my opportunities to properly prepare. The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any modifications.
Okay, we'll go back to live. Because that's where she says basically the rules of the internet are what the rules of the internet are. I'm not making modifications.
The phone system that we currently have in the jail for the inmates to access is as is. I don't have the ability to make any.
We're just going to get a special bat phone for Sarah where she gets to make phone calls and we'll just put an extension cord and run it to your room like it's 1990 and you're a teenager. Ugh. My parents just keep listening in. I have to shut the door with the cord on the other side.
Modifications. Number 8, discovery hard copies.
Here we go.
It seems that
I told you to stick a pin in that. If I'm allowed to have my 2 full boxes of hard copies, I don't see why I can't also have this.
Ms. Boone already has access to her hard The concern I have to do now is do some research with legal and my chain of command, because that quantity of paper can potentially become a fire hazard, and we have standards in place. And Judge, I'm not certain if you're familiar with the Florida Model Jail standards.
Gen X Gamer Girl says, I still want to know who she was going to call. My speculation, and I don't know, like maybe you guys can correct me on the timeline if I'm wrong, but we're talking August of 2024. So at this point, both Lana and Third Rail are fully involved with Sarah. So I imagine that she wanted unfettered phone access so that she could talk to them without it potentially having a phone calls from prison style jail record like Wade Wilson and McKenzie Shirilla. I still don't understand how her calls aren't part of that sort of a record, especially if she was committing crimes on the calls. Or, well, I guess if they're as inane as the stuff that we've heard released, then, you know, maybe that's why they're not part of the record, is they're as irrelevant as she is. But yeah, that's a good question from Gen X Gamer Girl. And I think she was wanting a phone to communicate with her Flying Monkey crew as it existed in August of 2024. Because this is right around the time, I definitely remember from the Tanika tablet messages, going into the trial, we were aware that there was the Delapine Creative Company that was talking about doing documentary work for them. And at that time, we didn't know very much about them at all. Interesting side note there, the Delapine Creative website is no longer available. So if you look up Delapine Creative, you'll see just a 404 error type web page now, no longer that ridiculous running chicken. So that's the way that is.
But the quantity of paper is actually the problem. So we may have to come back to the table for a different type of resolution regarding the two cases of paper discovery.
Yeah, we still got to figure out the two cases of paper discovery. Little side note here too, but as they pull around the room, you'll see that Mr. Cacciatore, they're in rolling chairs. You see the chair over here for the court reporter is a nice ergonomic rolling chair. They found Sarah a green chair that doesn't move to sit in. Just a little fun note for us Sarah Boonophiles.
Ma'am, do you have any questions regarding
Boonophobes?
Captain Giovanni's and the Orange County Jail's position with regard?
Boonaficionados? Yeah, I don't know what quite. It's not file though. Those are lovers of. We're lovers of the downfall of Boone.
Regard to the earphones, headphones, internet usage,
Speaking, this is completely off topic, but for people who are a fan of JD, A Lawyer Explains, I was watching a video from him, October of 2024. I believe the exact date was October 22nd, 2024. He used Boondoggle. Boondoggle with the Boone doggle, portmanteau, but used Boondoggle to describe Sarah's situation online one day before Third Rail had a channel. So credit to JD, A Lawyer Explains, for coming up with Boondoggle and using it correctly. I know Dreadful Penny 2, another fun channel for some Sarah Boone coverage, is annoyed by the fact that they spell Boondoggle just like the dictionary way. As a parody and satire person, I love that they did that because I can throw Boondoggle in all of my titles and it's just an English word, so they can't trademark it. I can parody their stuff, and anyone who goes looking up Boondoggle content gets delivered some dandy little fresh slice of truth and honesty with a musical backbeat. Yeah.
Processor, telephone, and the concern regarding the hard copies and it being a fire hazard.
I do, and I was also including number 3, the classroom utilization. I just want to make it clear and in open court that I want to have the understanding.
She says clear and in open court. What she really means is like clear and on the record for an appeal, but she doesn't realize why people say that they want stuff in open court.
With everyone that it is an option of mine to decide to remain on my bunk with this discovery in the laptop, and it is or
Hey,
my
Bella's
option
mom.
to be moved, but I have the ability to make that decision.
Judge, I have no objection to that. I am not looking to impede anybody's ability to access to a general population housing unit. I was simply offering an option that would be amenable to security.
It's a fairly good
and
option.
Potentially Miss Boone.
Do I have to decide right now?
Am I able to proceed?
You can.
Thank you.
So for my understanding right now, you need to speak to your legal counselor in regards to the headphones, the internet, the Word program, and the discovery hard copies, which I already have. Is that correct?
And telephone access.
Oh.
You want unfettered telephone access.
Unfettered.
If I read your letter correctly.
Reasonably, I would like to have access to a regular phone. It could be 1, maybe 2 times a week where I save all of my calls for a particular day. I'm always up for solutions, just whatever it is that I can do in order to progress properly and expeditiously. I'm trying to do.
I'm always up for solutions.
So by having this where I am confused why this was not all solidified prior to the implementation of the laptops.
Here we go to the trailer. Thank you. This is my first time doing a trailer for a live. I think I'm going to try and do this more often, but find something I'm looking forward to in the live, do a 2 or 3 minute clip of it, and then maybe a longer 5-minute video. And then that way more people are aware of the fact that I'm even doing these rewatches. But if this sounds familiar, it's because it was in the trailer that you might have watched while you're waiting for today's episode.
So I'm waiting for whatever it is that I can do to fully access and become a pro se defendant and inmate. Do you know when, how long the deadline might be for the open-ended items that I would be waiting for?
Judge, this is Scott Chapman. I'll chip in with the legal piece of it. The legal piece of it is simply that she's a pro se inmate. She's not the first pro se inmate that the jail has had. We've had several. And the issue is whether or not there's any constitutional or statutory violation with what we provide pro se inmates. And I would argue that there's not. She has access to the court as required by the law. Everything she wants is over and above what our typical stance is for pro se inmates.
Hold
and
on.
all those policies are in place for a reason. But somehow she wants to go beyond that, and she wants all this extra.
Okay, so we've had one over and above, which means I need to pause and set up an over and above counter. But that becomes, if you remember Pee-wee's Playhouse, they used to always have like a word of the day, and everyone would just go crazy, and they would tell kids, like, when you hear the word of the day, you just scream like mad. Don't tell your parents why you're doing it, just do it. So parents loved it, but in that vein, I'm thinking that this is the phrase of the day, because we'll hear it a lot now. What I'm doing is looking up something that says counter as a sticker, and then how am I going to change number incrementally? I should have thought of that before I started doing the counter. Oh, no, that's not going to work. Okay, I'll just hit the ding every time I hear above and beyond. We'll see how many dings we get. Above and beyond comes up a lot. The last 40 minutes of this video.
Consideration, more than anybody has ever been given, frankly. And at the end of the day, again, it's a constitutional question. Is it a violation of her constitutional rights, the restrictions we have in place? And I would tell you it's not.
Is that a position, Counselor, that you're taking today? Because Captain DiGiovanni had stated she needed to consult with legal counsel as to the issues of the headphones, internet, word processing, telephone, issues. Is that the position that you're taking today, or is that something you need to further investigate to have a final position as to that?
No, that's my piece of it from the legal end. Now, of course, she's got to talk to her folks as far as the security end of it, because a lot of those things are in place because of security concerns. But from a legal concern, I can easily answer that today. And the answer again is, legally she's allowed access to the court and all these other things that she wants in her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests as to the headphones, internet, word processor, or telephone?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior.
So that has nothing to do with what Judge Kraynick just said. Let's even rewind it. Judge Kraynick gave her clear parameters, and instead she's focused off of she was triggered by Scott Chevenel, and all she could think, kind of in the same way that near the end of the trial, when their victim impact statements are being given, and George's daughter says, for a lot of you in this courtroom, this is just another day, but for me, this is forever. And Sarah probably didn't hear the part about other people in the courtroom, but just heard her say, for me, this is forever, and took offense, like, yeah, it's forever for me too. And it's like, yeah, you're not who she was addressing. Anyway, Sarah was so triggered by that, she let it infect her whole Kintu Sukuroi forgiveness speech, where she kept talking about, this is forever. This is forever. Anyway, she gets distracted by Scott Chevenel and can't answer Judge Kraynick's very clear, do you have any questions regarding the phone, regarding the laptop, regarding the access?
Several attorneys are pointing to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
Ma'am, do you have any other argument with regard to these requests?
Any other argument with regard to these requests?
As to the headphones, internet, word processor, or telephone?
Headphones, internet, word processor, or telephone. What are you going to ask about, Sarah? Which of those four?
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate?
Hairball Yarn has joined the chat. Thank you very much. One thing, I think I'm on subscriber only chat, so if you see somebody chatting in the chat, they have subscribed, so thank you very much. I'll give a live subscriber update when we move to the next video. We still have about 30 minutes left in this video, so 45 minutes of this commentary. And then I think about an hour and a half in the follow-up, the James Owens joins the team video that we'll be watching next.
Of the Orange County Corrections Department?
I'm not going to answer that question.
I'm not going to answer that question. I love how Scott Chevenel jumps in, though, because later he's like, what am I, a witness here? But on this one, he can't help himself. He jumps in before Judge Kraynick even says that he's not going to.
Standing in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate of the Orange County Corrections Department?
I'm not going to answer that question.
Not being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other pro se inmates, what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. And I'm pretty sure that they were not able to complete their case in the successful outcome that they were hoping for by being provided simply papers and pens.
Notice she does the little head turn like a dog again, like Why are you not responding? I'm not getting the response I expected from what I just said. It's because you didn't didn't ask a question. Your questions are supposed to be for Captain D. Giovanni, not for Scott Chevadel. But they give her so much time to just marinate in her stupidity here, so we will give her the same time. 109:41. 109:29 will be her still talking. Yeah. Let's just enjoy every second they let her marinate in her stupidity.
Their case and the successful outcome that they were hoping for by being provided simply papers and pens.
Counselor, if you.
No, I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney.
You're the attorney. This is where all of a sudden Judge Kraynick becomes a traffic cop. Like, no, you're an attorney. Hairball Yarn is the newest member to Dan D True Crime. Thank you very much, Hairball Yarn. She's the defendant. She's an awful person. Her name's Sarah Boone. She locked her boyfriend in a suitcase and mocked him. For everything you done to me. For everything you done to me. And that's why she got the buzzles and the paint. Welcome, Hairball Yarn. Let's hear their response now that they've given her 12 full seconds to marinate in her stupidity. Judge Kraynick, what is everyone's roles here?
Attorney for
Right.
one of the participants,
Right.
sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
They're simply requests.
They're simply
And
requests.
I'm not sure who it,
I don't know why you would categorize these as demands. I'm not demanding. All right, we're going to give that a full... Let it have its full time to play without interruptions.
Counselor, if you.
No, I'm not sure if she's asking me a question. I don't know if I'm a witness in this case or if she's trying to ask me a question.
I'm not. You're just simply the attorney for
Right.
one of the participants, sir. If you're under no obligation to answer that question. You are just providing your legal position with regard to the Ms. Boone's demands and requests.
they're simply requests. And I'm not sure who it might be that could answer my question, please, in regards to what prior or present other pro se defendants and inmates have requested. So I might have a guideline of something to go with forward. And I, again, do not know what is above and beyond simply.
What is above and beyond? Well, Becky again is above and beyond. She just sent 5 Dan D True Crime gift memberships out. She's gone above and beyond. So Kathleen Roloff, Chowiva Mom, Mrs. Shan, Sarah Bridget, Jess Melissa, you've all received True Crime memberships because Becky again went above and beyond. Thank you so much. I really appreciate the memberships are they really mean a lot to me. It's I'm just going to take a quick break. I'm terrible at quitting on myself. Like if I, resolve to go to the gym and work out 3 times a week, chances are I'll go 0 times a week and not really feel bad about it. But if I'm part of a sports team or like I used to play soccer and I would get out every week, whether I felt tired, whether I felt, sore, whatever it was, because I didn't want to let down the team. And every time you guys buy memberships, it makes me feel like I'm part of a team here on YouTube. And I don't want to let you down. I want to be here every Friday because I know people bought memberships and they're enjoying hanging out. So I just wanted to let you know that the memberships really mean a lot to me. Not that, I prefer members over non-members. Anyone being here matters to me. But the fact that people are buying memberships and gifting memberships, it's it's not just a small thing. It's a big thing to me, and it really helps my own motivation to make sure that I'm delivering content for you guys that you enjoy too. So thank you from bottom of my heart. Just a real moment here.
Asking for more than paper and pens in order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
I mean, Judge, like I said, we've got tons of pro se inmates.
To the extent you want to, I gotta exhale before I talk. It's just rookie mistake. I've been doing it all morning. To the extent you want to respond to that, yeah, you know what, Judge, I'll throw a bone on this one too.
In order to properly and rightfully and lawfully represent myself.
Counselor, to the extent you want to respond to that, you can.
I mean, Judge, like I said, we've got tons of pro se inmates that have come through, that are there right now, that have come through the jail, and they get standard treatment, and she wants it.
Becky, again, has gifted 5 memberships. She just got herself a membership. Thank you, Becky, again. Thank you so much for gifting memberships before taking the plunge yourself and joining, but that's awesome. That's a way to think of other people first. That's pretty sweet. Anyone who gifts memberships too, nobody's really taken advantage of it, but anyone who, pretty much anyone anyway, but if you've ever gifted a membership, you get a free super chat. Just put capital SC at the beginning, like in capitals, and then, maybe in quotes what you want as a super chat. I'll pin it, I'll read it, and that's my gift to you. Thank you.
A lot of things that are over and above that. For instance, again, unfettered phone calls.
Thank you, Lakeisha.
She wants to keep things in her cell that she can't normally keep, that they wouldn't allow folks to keep. So there's a lot of issues. I mean, that's a wide open question. But, can I speak to everything that everybody's got in the past? How many pro se inmates we've had that have come through the institution? No, but I can tell you that, we could probably find plenty of examples, if need be, as to what people have received in the past. And it's nothing close to what she's requiring or requesting today.
Okay. Ma'am, with regard to your state, do you have any position with regard to any of these matters we've addressed? Okay, thank you. All right, ma'am. So with regard to your request, as to the laptop, this jail will be able to accommodate your request, and those extensions will be provided as placed previously on the record. With regard to your request to hold the USB drives in your own personal lockup, for the reasons identified by counsel, Chevenel, it's a matter of security, and the protocol which secures, controls, inventories, and ensures in good working order the USB drives will be complied with, so that request will not be accommodated. Your request for a classroom similarly cannot be accommodated for the reasons identified by Captain DiGiovanni on the record. However, there is an alternative housing offer that can be provided for you. With regard to your request for headphones, that has been rejected and denied by virtue of legal counsel's argument.
Think of it, headphones, like it's doesn't take the most imaginative criminal in the jail or prison to do something with a set of headphones.
And what is being provided to you. With regard to the internet, word processor, and telephone, again, for the reasons that counsel for Orange County has identified, those cannot be provided to you. The court does note that you do have the services of...
This is another time of him giving advice. He can't give advice, but he does note, and this is great because it's also on the record, showing, she's not some helpless pro se inmate with no resources of her own. Judge Kraynick, what do you take note of?
An investigator.
And
JAC provided you $10,000 and $1,000 for travel.
How do I get that $10,000? I just want it to be paid directly into my account, Mr. Kraynick. Do I make a motion for that?
Or your investigator. To the extent, as requested for the purposes of internet, for locating witnesses and experts, you have a personal private investigator that can utilize, who can do that for you.
Beth Serrano just found the channel and really enjoys it. Just got herself a free membership from somebody gifting it. That's fantastic. I think that's kind of explains my strategy for gift memberships too. I was just doing music videos to really start out, so there might have been people who, watched a few Dan D shorts and then kind of forgot about the channel. So every time you gift and one of those original subscribers comes back, they're like, oh, well, this has changed a lot in 6 months. There's a lot going on here. A lot of back catalog. So that's, your gifts are the gifts that just keep on giving, just like Sarah Boone to the true crime world.
I know you've made requests previously to look at your phone to find contacts and information. You also have a private investigator who would accomplish some of those tasks for you. And those can be communications and conversations between yourself and your investigator as to who and when and where and what persons you might be able to seek to find. So for those reasons regarding the headphones, internet, word processor, and telephone,
definitely a lot of
arguments
Elizabeths.
of counsel for Orange County, I'm unable to accommodate those requests. The jail is unable to accommodate those requests. Those requests will not be provided. With regard to the hard copies, that's going to have to be a matter. If it needs to be addressed, it can be readdressed with regard to the potential fire hazard. Captain DiGiovanni, would that still be an issue with regard to the fire hazard based on the amount of paper if Ms. Boone elected to move to the secured housing in the K dormitory?
Big welcome to Christine Garcia. You are also a member of the only level. Well, Sarah's contemplating a move to the Kilo dorm. Christina Garcia has joined the only level. Congratulations on your bloody keyboard. It looks like this is at least your second month of membership. So congratulations, Christina. And congratulations to Becky again, also with a bloody keyboard. So it does remember your initial memberships. If anyone's looking at the badges, the progression is Drunky the Bear to get started, a bloody keyboard for your second month, the Pro Se as your third badge, and there's an LWAP badge. That is the final form of Sarah. LWAP.
It's basically the Florida Model Jail Standard 7.12. The officer in charge or designee shall determine what personal items may be kept in the cell or stored with the inmate. However, an inmate shall be allowed to retain a reasonable amount of personal property, including but not limited to his or her legal material, personal hygiene items, writing paper, and writing instrument.
A reasonable amount. You can see Sarah quickly scrolling down because, she's going to say, I think it's only reasonable that I get all of it. Why wouldn't I be able to get the whole horse's mouth? I actually want the whole horse in my jail. Only reasonable.
And authorize reading materials in reasonable quantities as approved by the officer in charge or designee. Personal items will be kept in an orderly manner. Fire potential is reduced by limiting the amount of personal property in the cells. So it is...
Exactly. So let's say somebody, unrelated to Sarah, completely unrelated, has nothing to do with her. Not a co-conspirator, just prisoner sharing space, one of 399 other people in the OCC. Gets the idea of, I want to start a problem, and what I need is a bunch of paper so that I can start a fire. Who has paper? Oh, there's that bitch across the dorm that has 2 boxes of paper underneath her bed. I don't give a fuck about her discovery, but I could definitely use that paper.
The sheer volume of paper, and that is what I need to conduct an evaluation from. Now, in Miss Boone's letter, if you give me one moment.
Oh, she's going to read the letter. I got to go back to a slow speed. But Captain Giovanni decides to start reading in Sarah's voice, if she does.
In number 8, discovery hard copies, she writes the following: as I am presently, I can keep these in the permitted property bag.
This is perfect because her difficulty reading Sarah's handwriting combined with the slowed down audio really replicates you just have to pitch it up to get it to sound like Sarah, but the cadence with the language is just perfect.
Discreetly located at my bunk. I will purge the document.
I will purge the documents.
I have now and keep only new discovery hard copies. The remaining I can send to the property department and will purge anything already being stored for easy convenience and extra space.
She's always up for solutions.
I'm willing to see what she's going to purge and send to property. But at the end, I have to reduce any fire liability to the building in order to maintain security and safety for the 399 other inmates that I have.
When she says that, I totally think of Captain Kirk. Scotty, I'm responsible for the lives of 399 other crew members. I'm responsible for the safety of 399 other inmates.
Have here, along with the almost 100 or so assigned staff, civilian and certified. I will also say that pro se inmates in the past have been afforded a second fire retardant property bag, and I'm willing to issue a second fire retardant property bag to accommodate the excess, but anything over and above that.
Little spoiler. Do you think Sarah's going to accept the second property bag, or she's going to find a way to go over and above?
We may have to find an accommodation, and based on the willingness of the letter that Miss Boone has written, she articulates clearly that she's willing to purge and send to property any paper that's over and above.
Do you have any questions? Well, no, go ahead.
And I can have that second property bag upon her return this evening.
Okay. Ma'am.
Okay, so that sounds fair enough. We're going to take your boxes, but we can give you a second bag. What do you think of that, Sarah? How do you feel about a second property bag? Something over and above, or will a second bag do?
Do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag where I did attempt.
Dumb, 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 dumb. Sarah, who's able to fit George into a suitcase, is unable to figure out how to fit paper into a bag. She's just putting the full fucking box into a bag. Like, you know, she didn't play with toys, like, no spatial awareness as a kid. Like, sure, you can fit the circle into the square hole, but you can't put the square into the circle hole.
Numerous times, and even had others try to help me put it in.
Even had others try and help me. This is, again, another little, let's rewind it again to fully enjoy her stupidity. But yeah, she first is claiming to be putting a box in a bag that doesn't fit, and then asking other inmates to help her put these boxes into bags that it doesn't fit. That's like asking for help fitting something into your, you know, hatchback that doesn't fit. It doesn't fit.
Do you have any questions? well, no, go ahead.
And I
I'm
can
sorry.
have that second property bag upon her return this evening.
Okay. Ma'am, do you understand the second fire retardant bag that could be provided to you regarding the hard copies of the discovery?
I do, and it was already provided to me, but the box.
Oh, that's another thing. And it was already provided to me, so she already has two. She's already gotten this second bag that is supposed to be being negotiated for now. But it's useless to her because she's not able to put the box in the bag.
Unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag. I also did.
What a scene in the jail, eh? You know, 8 prisoners all trying to shove a box that doesn't fit into a bag that's too small for it.
Not know that they were fire retardant bags. I have the one already.
I didn't know they were fire retardant bags. If I did know they were fire retardant, what? That would change your ability to fit a box into it?
At my bunk, and I'm in the process of trying to figure out what needs to be purged.
Drink up
I also
from
have my
Yalgi.
second family law case that I'm trying to be able to obtain those copies at my.
Her family law case. So remember, that's still important to her. So in addition to all this shit that she's got crowding her bunk in the Big Bay, she's also got a box of family law documents.
Bunk as well, because of the difficulties of receiving and delivering anything to the property department, which is why I came up with the solution of me trying to purge what I can specifically, to be specifically removed from the jail completely by a friend who can come and pick that up. I was just waiting for this spring to happen so I can figure out when to tell her to come to do so.
Her friend, so this is maybe Christina Pena, who testified, was a former inmate with her and testified on her behalf at the sentencing hearing as a former inmate. The idea here is that Sarah will have looked through her discovery, determined what isn't necessary for her to look at, and Christina can go put that, in storage for her until the day that she futuristically gets released. Look at it at her leisure.
So is that accommodation acceptable?
It is. I returned the second fire retardant bag property.
She returned it because, I can't use this. It's stupid. So but.
Bag because I didn't want to have anything extra on top of my extra already. And it is not able to be used for anything that I can put in there, where I already have everything in the boxes in the one bag already being occupied.
You can't have the boxes. So right now she's got one bag, and in that bag she has 2 folders. And if you remember from the beginning of this stream, one of those folders is just full of her publicity, good, bad, and hostile, and otherwise.
Are you satisfied then with regard to the treatment, for lack of a better word, of the hard copies?
What do you mean by that?
Sure. Are you, the procedure for having them stored and where they're kept is identified today, is that acceptable to you?
Meaning I can have them where I have them now?
That's my understanding.
Okay, countdown until Captain D. Giovanni corrects Judge Kraynick's understanding.
Judge, may I say something here?
Didn't take long.
Sure.
Okay, and thank you for allowing me the interruption. The cardboard boxes are not authorized by the fire marshal. The fire retardant bags are. So the documents are going to have to come out of the cardboard box and into the fire retardant bags.
Okay. Seemed clear, right? There's a lot of dings there, but each one of those statements was correct. You can't have the boxes. You can have the bags. The paper's going to have to come out of the boxes, go into the bags. Sarah, was that as clear to you as it was to me and to all of us in chat?
Ms. Boone?
I would have to figure that out for the voluminous amount of paperwork that are contained in those 2 boxes.
Yeah, you will have to figure it out. You will. Do you think it'll be any easier to fit the paper in the bag when it's no longer in the box? Can you change the shape of paper to fit the bag if it's no longer in a box? Would that work?
And there is no way to organize or separate, so it would just be a large mass amount of papers. So if I may, in the meantime, try to come up with some type of organizational structure of those 2 fire retardant bags with my hard copy discovery enclosed in those, if I could.
Some type of an organizational structure, if I could, with my...
Please do so.
Mr. Chevenel,
Mr. Chevenel.
Giovanni, is there any way we can give her an additional bag or so and she can switch it in and out of property or whatever it may be? Can we provide her an additional bag that may
So above and beyond, this would be a third bag.
help her to separate her documents?
I could provide the third fire retardant bag, but
That's it.
it's the encroachment into another inmate's area. It's a limited space. But the cardboard box can't remain. And Judge, if you recall my request, I had asked for all of this to be placed on a USB drive so that we would not have the paper in the jail for this.
Exactly. So anyone who watched 2 weeks ago, we were watching the hearing where they were talking about digitizing everything so that she would be able to store it at the jail. Sarah pulled some kind of a fast one to say, oh, the captain said I could have it. It's my discovery, because it got delivered and whoever was on shift was like, I don't know what to do with it. I gave it to her. Captain D. Giovanni was not happy.
Very.
And I understand that. And Ms. Boone has continued to request the paper copies.
She's continued to request the paper copies.
That's why everything was digitized, so that she would have that access to it. Everything has been digitized, but she has continued to request for those, and we're trying to make that accommodation for her as well. Yes.
Scott, if everything's digitized, why do we have to get the paper?
It's a great question, but Scott accidentally gives a little legal advice to Sarah.
That's up to her if she wants paper or not. That's fine.
All right.
All right.
It was never my decision to have anything digitized in the first place, and nonetheless, it's
She totally was asking, because at the beginning she's like, I don't know why any of this wasn't solidified before the laptop. She just wanted the laptop and the hard copies. She just wanted to be able to do both.
put on a laptop that is not even fully accessible because some of the programs do not work, which I have not had the time yet to continue to go through everything that are on the USB drives.
Which I have not had the time. All you have is time. You have 8 hours a day that got extended to 10 to 12 hours a day. Yeah, and you've looked through not more than one. Whose fault? Your fault, not ours.
And that being not my decision, and nonetheless, and most important to me, they are limited and restricted to particular time periods. When those laptop times are closed for the day, I can therefore pick up the hard copy discovery, be it in a fire retardant bag or in a cardboard box or whatever else it is that I'm able to keep them there at my bunk.
Wants to be at her bunk, because again, she was offered you could have all these hard copies in your cell.
That as Plan B when Plan A is closed.
Judge, if I might be able to offer a resolution here.
Okay,
What do we got?
Was the discovery that Miss Boone received, was it just a stack of papers in the box, or was there any type of manila envelope or filing separation system?
I haven't looked at them. I haven't copied them. They were opened in court back in, I think, June 28th, when we had the hearing where the court found that Ms. Boone had forfeited her right to court-appointed counsel and alternatively have waived that right by virtue of her conduct. I believe the box was open at that time, and there may be manila folders for some of the items, but I can't speak to all of it. I haven't reviewed it. I'm not able to review it.
I just have to go to the bathroom. I'm going to leave it play, but listen to the use of the word folder and envelope, because what happens here is Captain D. Giovanni does, she said envelopes first, then says folders. Folders goes back and forth, and then it comes back, and Sarah is kind of rightfully saying, you know, you can give me folders, but the papers are just going to be loose and would go everywhere. And then Captain D. Giovanni says, well, that's why you would use the envelope, and the envelope would contain the papers. Anyway, that's what happens in the next 2 minutes. That should give me enough time to go to the bathroom and come back.
Would Miss Boone be able to indicate whether the paper is free-flowing paper, or was it bound in some way?
Ms. Cashman had represented that all staples had been removed and all paper clips had been removed. Ms. Boone?
It is a mass amount of paper.
Are there dividers? Are there manila folders?
There, I believe, are 2 manila envelopes that have contents inside.
And everything else is just free paper?
As far as my understanding is, yes. I've not been able to fully dive into the boxes quite yet because of waiting for information for this. But I can further explore once I return back to the dorm.
I can provide some manila folders without any type of clasp or string in order to get the cardboard boxes out of the building.
I understand, and that would be appropriate. I don't know if I'm limited to a certain amount on top of the specified pen and papers I am able to have. My question is, I would like to know also, please, for the reasonable quantities that you quoted earlier in regards to the amount of paper, is that the definition that you provided, is that for the enclosed housing area, or is this also for general population?
Ma'am, I'm responsible for, based on the Florida Model Jail standards, to reduce the amount of paper clutter in all living spaces. It's not specific to just your housing unit.
Thank you.
Captain D. Giovanni, does that now? Can she switch out and get things out of the property within reason if there's additional documents in her property?
Through the request form, if she, we're going to authorize the second fire retardant bag. We're going to offer some manila envelopes without a metal clasp or string.
Envelopes.
So that she could get everything into the fire retardant bags. And then we're going to remove the cardboard boxes, which are...
They're a no-go.
Becomes is the fire risk, because it is not authorized or recognized as a, fire retardant item based on the fire marshal. The only thing that they consider fire retardant is the bag. And again, I will provide that. And then anything in excess, she could send to the property room. Well, and then upon her need for it, she could write a request to the property room, and the property room will bring it over. But she'll have to swap it out. I'm amenable, I'm amenable to her keeping her documentation. I'm not looking to take anything away from her, but it has to be in accordance with, fire marshal and policy.
Sounds
I understand.
No, you don't.
And I would be happy to comply with the extra bag and the manila envelopes for...
She would be happy to comply. Now, if you want to see Sarah Boone happy, stick around, because we're going to be watching a video that has Sarah Boone at her happiest. I literally, like, even game show Sarah, even, Sarah high school pitcher, not as happy as she was the day that she got to show up to court and show everyone her circus ad worked. We'll be watching that in about 20 minutes. Thought I was going to transition real smooth there.
Separators in regards to that.
So, ma'am, if the jail was to provide you those manila folders for the hard copies and a third fire retardant bag, is that acceptable?
It is if I do conclude that I need anything additional in order for them to be able to be held together in regards to some type of rubber band or some type.
At this point, they've said envelopes a couple of times. So again, it shows that Sarah isn't able to maintain and focus nearly as well as she thinks she is, because she misses key details by hearing, whatever triggers her into her notes, okay, this is what I'm going to say next. The minute she has that transition in her brain, she can't hear what's happening around her. They've mentioned envelopes a few times now, but she's worried about the papers just being free-flowing and is talking about getting elastic bands and envelopes, or elastic bands for her envelopes. I do like that Captain D. Giovanni kind of gives a couple just blunt no's.
Elastic, something to be able to bind the paperwork together. Is that a possibility?
I didn't hear the question.
You may have to speak more clearly into the microphone in front of you, ma'am.
Would I be able to, please, if I needed, to have a type of rubber band or some kind of elastic in order to bind?
No.
And I know, Captain, that you are...
No. Sometimes, less words do way more. Take that as a notice there, Sarah Boone, throwing out 400 words just to say two. No.
Are aware the courtroom is not in regards to the property bags that you all do supply. There's no rigidity to them whatsoever. It is just a floppy bag. So when you pick that up, everything goes in the middle. So there's no type of there's no way of actually being able to make...
There's no structural integrity to a floppy bag, is what Sarah Boone's trying to say. Maybe you needed Pretend Son there to help you out, but Pretend Son doesn't like you any more than Real Son. Welcome to the chat, Pretend Son.
Sure that one pile stays in the one pile and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
Yeah, she said envelopes now a few times, but tell us about your manila folders.
The purpose of the manila envelopes is that you would put the paper in the manila envelope, and that manila envelope keep paper in order.
Okay, so they're envelopes, not folders, and so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together?
The purpose of the manila envelopes is that you would put the paper in the manila envelope, and that manila envelope keep paper in order.
Okay, so they're envelopes, not folders.
Correct.
Thank you.
And that's a fairly simple solution, like all of that, envelopes. Oh, yeah, envelopes would work. To take the paper out of the box, sort it into envelopes as needed. You don't need to gum the envelope. You can just fold the flap in, put all those envelopes in the bag as they fit, rather than trying to put the whole box in the bag. Oh, Sarah, always up for solutions.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
And Janaski.
Not in regards
Welcome
to
to
the
the
hard
chat.
copies, no.
Okay, all right. Is there anything else, ma'am, that we need to
Neighboring
address
province?
today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
If I may conclude with the remaining amount of questions I have in regards to my requests. First, what are you doing with that ring you're wearing? Can I have it? My ring, Miss Boone. Yeah, I know, but did you pay for it? My ring, Miss Boone.
Is it Mr. Chevamel?
She wrote it down, right? I told you to remember Chevenel. Mr. Scott Chevenel, appearing for the OCC jail. Sarah made him say his name twice. She wrote it down. Sorry, can you please repeat it again? But say it for me like you're at Muldoon's and it's near closing time. How about you do that for me, Sarah?
Copies now.
Okay. All right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Sure. Even at this slow speed, Judge Kraynick's sure was almost just normal. Sure. It was just a little more casual, which shows you how sharp he was. Sure. With it.
Is it Mr.
Pronounce it like you're drunk, okay? It's Muldoon's. Closing time. You're finishing your drink so they don't pour it out as you're going out the door. But you need his name so that you can call him. Maybe he's going to be the new Brian. How do you pronounce it? He told it twice.
Shabamel?
Shabamel. That's almost like silver bells. Shababel. Hear them smell.
Questions that I have in regards
It's Christmas
to my
time. I'm in Lowell.
Sure.
Sure.
Is it Mr. Shabamel?
Yes.
He doesn't correct her. Just get on with it. Yes.
Could you please provide me with the
Little spoiler. It's a no.
protocol or policy that you will have a guideline for me to follow, please, in regards to what previous pro se inmates may have
Yalgarita has a suggestion for a new dandy song parody. Closing time. Last call for alcohol. But it's set inside Muldoon's. Sarah, you don't have to go. Yeah, I could work on that. Closing time at Muldoon's with Sarah. I don't know if I can do it as a sing-along because it's maybe a little outside my range. But yeah, maybe there's something I could do to the lyrics on its own because I think there's a match for Sarah within those lyrics.
had access to and be able to utilize? Do you have anything in writing as a hard copy?
Would check. Do you ask for? Are you making a public records request?
Sarah's head turns again like a dog that just heard. Did you say walk? Are you making a public records request? Can I do? Is that something that I can do? What is a public records request? Please tell me more.
I'm sorry?
Are you making a public records request?
Because if you were, oh, you know what's kind of cute here too? I'm going to listen to this at full speed because we already just listened to it short. But I'm going to reframe the camera. There is a bailiff in the right-hand corner of the screen, just basically where I am. I'm going to move the screen a little bit so that you can see her because she is amused with Sarah. She has a look of pure mirth on her face. He changed the scene slightly. Shrink it up so that you can see everything. We will be peeking in just over the Court TV logo as Sarah discusses this. Oh, that's the wrong one.
Questions that I have in regards to my requests.
Sure.
Is it Mr. Chevamel?
Shemamel. This is the moment that the bailiff leans in and starts grinning.
Yes.
Could you please provide me with the protocol or policy?
She knows it's not Shemamel. Like, I'm sure if this is the attorney for the jail, I'm sure she knows it's Shevendell. And she's just looking at Sarah now.
See that you all have a guideline for me to follow, please, in regards to what?
Oh, yeah, that's 100%. I'm blowing that up a little bit more because I didn't realize I was correct as I was. Center of this. Do that so it's above me, and we'll get rid of the Devondell tagline. Okay, so right above me, where she is, and you can watch her reaction to Sarah. Well, no, not in real time. I'll slow it down to 75% time so we can. Too slow.
Previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Do you ask for?
In order to keep those together?
The purpose of the manila
Copies, no.
Okay, all right. Is there anything else, ma'am, that we need to?
And so on and so forth. Do you have any suggestions other than manila folders that I might be able to utilize in order to keep those together? Everything goes in the middle, so there's no property bags that you all do supply. There's no
What have I done?
in regards to some of rubber
policy.
Okay.
clue that I need anything.
No.
Oh, I flew too close to the sun there. Okay, so I know it's after the no.
Order.
Okay, so they're envelopes, not folders.
Yeah, that's
Correct.
Thank you.
Ma'am, is that acceptable to you? And is there anything else we need to address with regard to the hard copies?
yes, Mr.
Not in
Shemamel.
regards to the hard copies, no.
Okay, all right. Is there anything else, ma'am, that we need to address today, Ms. Boone?
Yes, please, if I may conclude with the remaining amount of questions that I have in regards to my requests.
Sure.
Is it Mr. Chevamel?
Yes.
Could you please provide me with the protocol or policy that you all have a guideline for me to follow, please, in regards to what previous pro se inmates may have had access to and be able to utilize? Do you have anything in writing as a hard copy?
We'll have to check on that. Do you ask for? Are you making a public records request?
I'm sorry?
Are you making a public records request?
I'm unclear of your question. I was just asking if the Orange County Corrections Department had any type of guideline that you are accusing me of going above and beyond, other than the pen and paper. So I didn't know if you had a policy or process in, if you have a pro se packet, like JAC has a pro se packet, does Orange County provide something like that?
You'd have to ask the jail that question. I don't know. I advise from a legal standpoint, and I can certainly tell the jail what the legal standard is. I'm not going to advise you as to what the law is, but I'll certainly advise the jail as to what the legal standard is.
Yes, please.
Yes, please.
Captain, I would be...
Yes, please. It's like she thinks that she just asked him to explain to the jail what the legal standard is, and it's like, no, I'm not doing anything you ask. I'm not working for you. I work for the jail. I'll do whatever they ask me to. If they ask for help, I'll give it to them. You can hire a lawyer if you want that kind of legal advice.
Responding to you in regards to that or following up with you or Sergeant DeJesus?
Ma'am, we don't have any access to that. I don't know anything about what other inmates that are currently pro se get other than that laptop and the information transferred to a USB drive.
Yes, ma'am. Thank you. And Mr. Shabamel, you...
Sorry, did you just get it worse? Did you just get it worse? More confident, but worse.
Yes, ma'am. Thank you. And Mr. Shabamel, you...
Mr. Shabamel. It's going to show my age a little bit. If you remember the old Sesame Streets when Mr. Hooper was still part of the show, that was one of the running gags, was that Big Bird could never remember Mr. Hooper's name and called him Mr. Looper and Mr. Cooper and Mr. Blooper, but never Mr. Cooper. And it was, I don't know, just a funny gag. I almost see Sarah doing this to Mr. Shabamel. So, Mr. Shabamel the Bell, you wrote it down. Chev and L. Chev and L.
Repeated that I have access to the court. Could you please define to me what your access to the court is for me?
Yeah, I'm going to object. I'm not a witness in this case. I'm really counsel for the jail, so it's really not appropriate to ask me questions. I know I've entertained a few, but I'm really not required to answer any.
Ma'am, he's not in a position to answer those questions.
Could you please answer who might be able to? Because I am in...
Could you please answer who might be able to? Again, ma'am, you're not getting legal advice just by asking questions in court.
desperate need to view the case docket, which requires internet, and
I'm in desperate need to view the case docket. No, your flying monkeys can view the case docket. They're telling you what happened. You're upset that they're telling you what happened, but you've got full access to the case docket.
Still waiting for any documents that you have mailed to me. I am unprepared, it seems, every single time now sitting here at the counselor's table with not the same information and opportunity. And
triggered a few memories of Mr. Cooper, Mr. Looper, Mr. Stooper. Loved Mr. Hooper. That was like I learned on Sesame Street. Those were some of my my formative years. So I learned how to count to 12. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
And advantage as everyone else in the courtroom because I'm waiting for the mail. So I didn't know if anyone had any other suggestion of how I might be able to receive those more expeditiously and in a timely fashion so I can be prepared in order to properly defend myself in apparently more than one way for every time that I'm here.
I think Mr. Hooper dying too. I remember that being a very early but poignant, reality of death kind of thing, and the Sesame Street creators treated it. It was good. Like kids, kind of need to know that life is impermanent, and sometimes things just happen. And if they glossed over it, it would have made it that much harder for parents who had to explain loss to children as it happened in their lives later. So, that was a formative part of my childhood.
In the courtroom, and something new is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify.
If I may
my
please.
understanding is the
This is early clarification, Boone. Could I make a motion to clarify my motion to clarify the motion for clarification?
The only way that I can receive anything is through United States Postal Service.
USPS, ma'am. Not going to further. Good for Judge Kraynick, too, because somebody in chat, Hairball Yarn, says the strategy of asking questions until someone just gives in because they're tired of her has worked her whole life, and she's mystified as to why it doesn't work in court. And Judge Kraynick just showed it. Like, not going to answer you, ma'am. So the only way I can get mail is through the court. And that said, Judge Kraynick gave a clue. You have an investigator. Your investigator has a budget. If these are things you want, you could ask your investigator to get them for you. That said, he's never explicitly told her. He's just said the court take note. The court takes note that you do have an investigator.
Is presented to me as a surprise. So I'm just trying to avoid those.
Items will continue to be mailed to you at the appropriate address as required by the rules of judicial administration and general practice.
So if I may please clarify, my understanding is the only way that I can receive anything is through United States Postal Service.
I'm not going to answer that question because that would be me potentially providing you legal advice. But what I can tell you is that items will still continue to be mailed to you as required by those rules.
If I may please just make sure that everyone is aware that I cannot be properly prepared, as you can see now and prior. I just want to make sure that everyone is aware and understands that.
I just want to make sure everyone is aware. So basically, she just wants credit. So when it comes time for her grade, her final grade to be offered on her pro se representation of self, she gets credit for the fact that she was unprepared. We'll put it on your record, ma'am.
For the reasons that we've discussed previously, I understand that. You're entitled to that opinion as to your pro se representation of yourself. Anything else that we need to address today? Ma'am.
Yes.
Yes, there is.
I have a motion that I would like to submit, please.
Okay.
Ooh, a motion. Now, this is funny. So this, if you remember the very beginning of the stream, had Sarah spend about 15 minutes reading the motion from the media. Again, that was moot because she really had a background deal to do this outside of the courtroom, but still fought the media every step of the way because she didn't take the time to realize that Mr. J had offered her an alternative. But now Sarah's going to deliver this motion, and Judge Kraynick is going to read it on his own time with everyone else here in the courtroom.
Is there anything else that the jail needs to participate in with regard to this hearing?
Captain, would I be following up with you, or who would I be speaking to when I return to the dorm?
In regards to what?
I'm wondering in regards to the guideline and when and how the discovery hard copies, will the property bags be waiting for me when I return?
I will take care of that with my supervisors that are on shift.
Yes.
We will need the
Yes.
cardboard box so that we can dispose of that properly.
Yes, ma'am. And if I may,
Hey, Kitten
do
Pusher.
you know why it was not approved prior when a supervisor was the one who delivered it to me?
I have no information about even the amount of hard copies. I didn't even know that that came into the jail because I
Didn't even know it came into the jail. So this is where Sarah kind of, I think somehow finagled her way of like, oh no, I'm supposed to get that. If it's delivered by the court, you have to give it to me. And then Captain D. Giovanni is like, what the hell is this doing here?
my conversation has always been that everything would be digitized and that we would have no hard copies so I could be in compliance with the Florida Model Jail Standards, Orange County Fire Marshal, and our policies and procedures regarding excess amount of paper.
Yes, ma'am, I understand. Thank you very much for your time. And Sergeant DeJesus and Mr. Shebamel.
Okay, are they free to leave?
How was the she got in one last one. I didn't even, I thought there was only two. How's it this time, Sarah?
Jesus and Mr. Shebamel.
Got the Chev that time, but still, Chevamel Shimel the killer. Killer. Shimel.
Yeah, are they free to leave?
Yes, thank you.
State? All right, thank you all very much.
Thank-
Ma'am, you made reference to another motion or something else that you had.
Oh, that was also key. So Judge Kraynick knew that he was going to waste a little time with this motion and let the jail people go. Didn't realize that at first, but he made it clear that they were able to leave, and now he's going to do this little thing, little half measure of revenge against Sarah's time wasting earlier.
Yes, I have a motion.
Okay, if you can hand to the deputy behind you. Actually, deputy, can you hand it to the state? State, you can take a look at it, and then I will.
Watch how much time Mr. J needs to look over this motion. And he's done.
Thank you, sir. All right, ma'am, give me a moment to take a look at this.
All right, I have 135.29, 135.30. We can talk amongst ourselves. I'm going to even turn the volume down just a little bit because not much is going to happen now. Judge Kraynick is reading this, and we're getting ready for the next hearing. Next hearing is Sarah at her happiest. Oh, is that? Yeah, okay. I'll take it off of one of my ears. It's just as loud in my ear, whether I turn it down or not. But it's just loud white noise, so it's a little bit distracting for me. I know that Judge Kraynick will let us know when he's going. Just so you know, it is live video up there. This is Judge Kraynick taking his own sweet time, listening to or reading Sarah's motion. I'm having such a good time with you guys. We're sticking around for the next video. It also purports to be about an hour and a half long, but there's about 20 minutes at the beginning without any audio at all, but there's some very interesting video, so I don't think it'll take quite as long to get through. I think an hour and a half.
The court has been provided a motion for payment of costs and appointing a neuropsychologist to assist the defendant in preparation of the defense. State?
The Judge Kraynick took 1 minute and 10 seconds to read her 3-page document and is able to respond intelligently and responsively to Sarah's probably meandering motion. Sarah spent 15 minutes and had no intelligent addition, response, or reply to the motion that she wasted everyone's time reading. But I love that Judge Kraynick took the time to do it right there. Like, do it now?
I don't think we can have a hearing on this without JICS.
State takes no position. We don't have anything to do with this.
Okay.
And this is just about her wanting to hire a new neuropsychiatrist, neurophysicist. It didn't end up playing. This person didn't come on board after James Owens takes over. But that's what this motion is for. It's a funding request, and without JACS, they can't even address it. But,
Ma'am, I can't have a hearing on this today. I will have to coordinate a hearing with regard with JACS to have this heard, because this is something that involves them.
Right.
And they haven't even had the opportunity to review it yet.
And they are copied on that as well.
I do see that, but you're hand filing it with me right now.
Right.
Mr. Bechamel.
So the court will file this in the court file.
Bechamel.
And we'll coordinate a hearing as soon as practical with regard to this motion, and it'll be heard before the end of this week. Anything else, ma'am?
Just to confirm.
He does stop saying anything else to her at a certain point. He definitely is focusing it more where he says anything else about. But yeah, you leave Sarah an open-ended anything else, there'll be something else.
Please, for the next deadline for my responsibility to meet would be the August 23rd for the objections to the state's USB drive that they provided.
So August 9th, 2024, she was provided a USB drive with the evidence the state intends to use from all of her discovery. So they're kind enough to say this is the stuff we're using, despite all of this being your discovery. We're going to use, this 10% of it in your case, and we've labeled what it is. So that's her opportunity now. She has 14 days to object to any of the stuff that the state is going to bring as evidence. She still has access to the rest of the discovery if she wants to use it in her own defense, but they've clearly identified what they're planning to use. And at this point, now she has 9 days.
Identified in the court's order. That is the deadline. The only other deadline, ma'am, is the September 3rd deadline for the viewing of the state's physical evidence.
Which is going to happen in between now and the next video we see, because we'll be viewing it at the sheriff's office, and the next hearing will be the Welcome to the Party James Owens hearing.
Which sounds like that's something that may take place prior to that deadline. As you may recall, you will have 14 days after that evidence viewing to tender any of your objections in writing to the court, 14 days thereafter, and that will be extended for good cause shown. Anything else, State?
Nothing, State.
Ma'am, anything else?
No, Your Honor.
All right.
A rare no. A rare no. She ran out of things. Meowgarita brings up, I love that everyone thinks that the bailiff is cute as fuck. Love her styling every time. That was a long pause in between. It's because I memorized the first half of the statement and completely forgot the second half and had to find it in the chat.
We'll return Ms. Boone back to the custody of the Orange County Jail, and we'll coordinate the hearing appropriately. Thank you all very much.
There is one more thing. Oh, forgive me. Even though you did say, is there anything else? And I said, no, there is something else.
In order possibly for a solution for me to know about the hearing, especially for the one regarding the JAC, is it possible for you please to relay it to Mr. Lane and he can tell me sooner than the mail?
Sarah, realizing she has an investigator. It was hinted at. We discussed it. Judge Kraynick brought it up twice, took note of it for the judicial record. Yes, Sarah, you could have your investigator phone you to tell you about something.
I can certainly do that.
Going forward, so I would have some opportunity quicker than waiting for the mail.
We'll see you on the replay, Anjanaski. Thanks for making it out.
Certainly advise him of that, or my office can.
I would suggest both, Your Honor.
Sure.
Billy Lane from the back of the trial room. I could do that, Your Honor.
Okay, I understand. All right, just so for recap purposes, with regard to the motions to intervene as first addressed this afternoon, the court orders that the defendant has failed to meet the burden of producing evidence and proving by a greater weight of the evidence that closure is necessary as required by Miami Herald Publishing Co. versus Lewis, 426 Southern 2nd, 1 at pinpoint 8 by the Florida Supreme Court 1982. As such, the defendant's requested closure of the state's physical evidence viewing with the state and defendant set for September 3, 2024 at 9 a.m. is denied. With regard to the other items that were discussed today, defendant and state agreed to an alternative arrangement as placed on the record on August 14, 2024 regarding the viewing of the state's physical evidence as tendered in open court on August 9, 2024. The state shall prepare for all parties to execute a notice reflecting when the evidence viewing took place and the length of time that the evidence viewing took place. The state shall file with the court the executed notice after the viewing of the state's physical evidence takes place. Defendant's request regarding extending the laptop time has been agreed to by Orange County. The times have been extended as follows: Sunday through Thursday, 8 p.m. to 10 p.m., and Friday and Saturday, 8 p.m. to 11 p.m. This is in addition to the times outlined in the memorandum from the Orange County Corrections Department Security Operations, which was previously provided to Ms. Boone and read to Ms. Boone. Defendant's request regarding the discovery that was provided to the court on June 28, 2024, and keeping that discovery in defendant's possession was addressed to defendant's satisfaction on the record on August 14, 2024, and the balance of defendant's requests cannot be accommodated for the reasons placed on the record on August 14, 2024. Ms. Boone, you'll be given a hard copy or hand-delivered a copy of these orders momentarily.
Thank you.
All right.
And you might have missed that, and I just kind of realized it as he was finishing. Judge Kraynick's like, no, you're not getting the last word. Oh, please, can I just say one more thing? Yeah, you can. But I close out these meetings. And Judge Kraynick took 3 minutes just to go right back through everything that happened today one more time, because I close these fucking hearings. Sit down, Miss Boone. All right, we're going to go to the next video. The next video is, oh yeah, look at that. Oh, so this is halfway through the video here. That will go full screen. Oh, she is so happy. She is fucking thrilled. Okay, and so this is 30 minutes into the video and nothing's happened. So I think what I'm going to do is just put the video on like 4 times speed while we watch it from the beginning, but I'm just going to skip us to the fun part right here. Sarah being brought in. Then we can talk amongst ourselves and have a relaxing, get to know each other, second video sort of thing. But that said, yeah, so there's only a half hour of true content on this one. There's a half hour of lead up to this trial, but for whatever reason, it's part of the video. There's still no audio. It's not me just turning it down. But she is pleased as punch. Oh, there's the frown. Is that where the frown came from? Oh my God, because that would, you know what? I've been looking to find that original frowny face. The one that everyone uses where it's just pulled down, gravity working. I never thought of this video because she's so happy. Okay. There. It's like she smelled like a fart just came through the room. Let's go. What? Oh, I'd lose my controls if I go too big. Okay. Okay, well, I'll leave it there and change the speed. Slow, there's no volume, so it doesn't matter. 33, back to 28. Okay, here we go. Oh, and K pauses it, okay. Oh, I've never heard anything so hilarious before. Oh my God, this is a good day. It's a good day to be in court. It's a good day for a great day. Okay, here we go. Smile gone. And is this her trying to like reset her face? There's the stinky. There's the squeezing out a fart face. She was so happy. I'm sure this is where the frown comes from. The camera. Fucking media. Bloody keyboards. Organized crime that is social media. You're already looking like she's going to get back to mirthful, though. Oh, okay. No, there's pouty face. That's probably it. I don't think that's the screenshot, but maybe somebody took a photo in the courtroom? That's not quite like... It's the face, not where the screenshot came from. I was almost of the opinion that someone used AI to make that, and then everyone loved it so much that we all just use it. But and now it goes back to happy. I feel pretty, so pretty and wise. Oh, what a pity. Okay, let's go back to full speed. And back to the beginning. That said, if we are going to go back to the beginning, there's not much going on, so we'll play it at fast speed. Go 4 times for premium speed. Okay, so we're doing that. Doing that while we talk. Maybe I should kill the volume on it slightly. We'll cut the volume to half. I don't volume happening anyway, but cut that down, and then when it pops up into my ear, I'll know that something's going on. That's kind of cool. We're seeing all the tech stuff. Got flirty eyes. I don't think I have flirty eyes. Deb Richardson's here. Phil for Dom Russo. A to B. Detective Wolbefit. Yeah, it's the wrong angle for the frowny pick. Yeah. Maybe there's somebody in the courtroom that was able to take still photos, and that's where it came from. Maybe it was like a news... No, if it was newspaper, you would see the mapping. Maybe it was a digital photo that was used in a local Florida news story. I always assumed it was a screenshot from a video, but have I got a baked potato? Or are you talking about, yeah, the more I zoom in, the less crisp the the angle is. If I'm crisp, then you know it's not my potato lens. It's more of a matter of contrast. If I'm also a potato, then it means that my internet connection here in the Dan D True Crime basement is not as robust as it might be up in the attic. But fucking hot up in the attic now. Turns to summer and there's Judge Kraynick. He carries a satchel. Didn't picture him for a satchel guy. Okay, well, he's got his satchel on. He's talking with the court clerk, moving some papers around, enjoying a few jokes, talking about what they did over the weekend. There's the bailiff, new hairstyle. Oh, we got volume. Oh, only for a second. The volume's gone again. Coming back. Okay, I will return it to regular speed. We'll find out what's going on. And yeah, so my plan is to get through this video, and then let me just look down the playlist. What's next? Represent self, unprepared. Oh, there is first appearance of Mr. James Owens. If we really want to continue to have some fun and, close out the stream on a high note, I have footage from James Owens' request for snacks, motion for snacks. So we might close this stream today on the both the motion for snacks and the ruling on the snacks motion, which I'm not even going to spoil. If you don't know about the snacks motion, leave it all up as a surprise. If you're aware of the snacks motion, you know how satisfying it is for a rewatch as well. So that's what we'll close out today with. And then we'll be getting fairly near, I think next Friday we'll still be in pre-trial, but it'll be where James Owens calls Sarah Boone to the stand in pre-trial and gets her to commit to a bunch of shit that she shouldn't have, that ends up working against her in the trial. So right off the bat, it's no good for Sarah. Mr. James Owens, this is his moment. He knows everyone's looking. They even brought in special green chairs that move but he's sitting in the green chair that doesn't move. He's trying to show Sarah that he's, team player. I'm sitting back here in the green chair that doesn't move, just like you. I'm your lawyer. You can trust me. In the panhandle. Well, I guess he doesn't get to sit at the desk till he gets sworn in. At this point, he's just a guest of the court. James Owens knows that camera's looking at him for a reaction shot, and he's not giving it to him. Got the back of his head buzz special for this, though. There's no stray hairs. Could have straightened out that neckline, though. Oh, never mind. It's because he's so twisted. Might be straight. So at this point, our only introduction to James Owens prior to this, there's no reason for me to pause it, was him. Oh, maybe I do have the volume. I still have the volume low. We'll get the courtroom sounds in the background. Yeah. Our only introduction to him at this point was he did an interview on the courtroom steps, bringing up everything from George's brother and past offenses to battered spouse allegations. A lot of victim blaming. It's funny, just as I turned up the volume to the court feed, they turned it down. At this point, we can trust that there's still nothing happening. We'll leave. Well, maybe we'll put it at double speed. Double speed to get back to where we were, because it is still about 15 minutes away in real time to audio picks up and Sarah's brought in, so run this at double time so we can watch Mr. Owens and make sure if there's any cool screen grabs or anything like that. Oh, the power's gone out in Florida. This must be Hurricane Milton hitting. Live view. This is probably where the stream is going from. Is the court live streaming? But if you don't mind, please. Is this broadcast live on the Court of the Clerk site? Zeitgeist Amy asked an excellent question, and yeah, this is a great time to address it. Will you be doing a ramble tonight? My plan was to, yes, do a ramble tonight. I don't think I'm going to schedule it, but it will be late. The only reason I'm not going to schedule it is because I scheduled this one and then had trouble sleeping, worried about waking up on time for the schedule. So the evening one, I think I'm just going to say, hey, it's happening. And I have two choices. One is to just stick with random body cam. I have at least 2 or 3 hours of stuff that we can watch together that has been uploaded in the last month or so to various body cam sites, and it could be fun, just random, low stakes crime to watch. The other would be to do a more curated show on the Carly Gregg story. So Carly Gregg, she is I think she was like 13 when she killed her mom and her stepdad. Her mom was a teacher at the high school that she went to. The reason there was so much footage of it originally is because the family had security cam in their own home. So you could see when the crime happened. You don't see the crime on camera, but you see Carly Gregg walking like this with the gun behind her back, because she knows that it's on camera. Somehow, I don't know, like, shows the stupidity of youth that, enough to hide the gun from the camera, but not enough to realize you walking to the room and killing the person wouldn't also be evidence. But then used mom's cell phone to call her boyfriend, hey, when you going to be home? And tried to ambush him as he came in the door. So then there's the body cam footage of him trying to reconcile what happened with, the fact that his partner's dead and he just got shot, but is still alive. Anyway, so there's all of that. She ended up getting convicted, and it was life, even though she's, a minor, but upgraded minor. And regardless of all that, I saw a long crime video of the appeal. So the appeal argument is that in the sentencing order, they didn't make clear whether it was life without parole or life with parole. And the reasoning for this, that this is a question, is because she's a minor, even if she's being upgraded, do they have to revisit? I didn't quite understand everything, but I thought it was fascinating that it was basically a life versus natural life argument that was being argued in an appeals court. The appeals court itself was quite fascinating because it's 3 judges, one that's asking a lot of questions as it goes on, 2 others that seem to be just taking notes. But I can see how an appeals lawyer has to be a certain type, because you get constantly interrupted. The judge isn't, worried about making you look bad. If you don't know the law and you're trying to bullshit through it, he's going to call you on it immediately. He was holding the prosecutor to account for her assumptions of what, hey, if there's no parole, then it's assumed that a life sentence is without parole. Anyway, the reason I tell all this is that I think it might be interesting to kind of do a ramble, like I just rambled now on Carly Gregg, where we watch the original body cam, maybe some interrogation, maybe some of her testimony, if there is any, during the trial, and then follow it up with the appeals argument. The appeals, especially because I think it'll give us a window into what Sarah's appeal would be like if it gets heard. I don't think it's going to get heard, but if it got heard, the questions that these judges ask of an appeal, it could be very fun to watch how the ridiculous arguments get exposed for as ridiculous as they are. So anyway, those are the two ways we could go tonight. Maybe I'll make a poll about that while we're still, and we're on double time here. So it seems, if it seems like we're milking it, maybe I am a bit. Maybe we'll go back to 4 times. Gave me enough time to talk about all that. Yeah, we're about 5 minutes away from Sarah coming on the scene. I'll put it back to 4 times speed. Just. Oh.
Okay, all right, so I'm going to give you 2 dates. You don't need to memorize these. You'll be given paperwork momentarily.
Oh.
The first date is the date of your pretrial conference. That's where.
This is someone who has the misfortune of appearing just before Sarah, so the cameras don't go on him, but I guess they decide to tune in the audio. So maybe we'll listen to this at time and a half. Has nothing to do with the current case, but it'll give me the time I need to make the poll for the ramble.
We're going to discuss whether or not your case is ready to proceed to trial. That'll take place on November 22nd at 1:30 in the afternoon. And if your case is ready to proceed to trial, it may be tried during the 2-week trial period beginning December 9th at 9 a.m. Before you leave here today, make sure you give all your contact communication information to your attorney to your right, and I wish you the best of luck, sir.
Oh, and it stops immediately. Okay. Random body cam fun versus Carly Gregg breakdown. For random body cam fun, now that I've sold Carly Gregg so well, what do I have on the docket for that? Turn off chat for a second and just go on to my playlist here. One of them is a woman who they try and block in at a gas station. They know she's got warrants. They know she's going to try and run. You see how close the cop parks to the front of the car. And she's just like, what did I do? What'd I do? And another cop shows up on the scene. He's properly relaxed. He's like, don't worry about it. I got the stop strips. I'll take care of it. He's almost too casual. But it's what you need to be. If he was like, running to the car, then she probably would have immediately taken off, right? Anyway, he gets the spike strips. Regardless, she's out of there. And now it's like it's a 10-minute run on the highways. They lose her. You hear like, for Christ's sake, where'd she, like, they pulled over the wrong car. So it's kind of a fun one, and nobody gets hurt in the end. There's not like a catastrophic, innocent people involved that get hurt. So there's that one that's on that list. What else do I got? Oh, now we've slowed right down, so this is never going to get to where we need it to be. Oh, doing so many things at once. I can do it, though. I can do 50 things at once. But then I lose track of the 50 things prioristic because as a, B+ student, I got a few A's, got a couple C's. I did terrible in mechanics. Stupid me. So I was really good in academic classes. So I took mechanics thinking, the dumb kids are getting A's in mechanics. That'll be an easy A for me. No. Turns out that sometimes kids that are academically inclined are not mechanically inclined. I barely made it through. I was doing essays and English projects for other kids in the class just to get them to help me build something that I didn't get. My brain couldn't get it. So yeah, I will never denigrate people who are able to work with their hands and, work with tools, tradespeople, all of that. My greatest respect, because I think any kind of education you get about learning how things work, whether academic or with your hands, it's knowledge and should be appreciated for what it is. I don't have it. But yeah, not a straight A student. Okay, here we go. Bring her in. Happy. She's just walking on sunshine. Speaking of which, if you like Katrina and the Waves, check out my latest Dandy shorts. I have footage from these moments set to the tones of Katrina and the Waves, walking on sunshine. Yeah, that's a total smell the fart face. Which is something, if you're ever in acting, if you're on a stage or something like that and you don't know what to do because you don't have lines, that's like a little trick. You do the smell the fart face, and other people that are watching the play aren't really going to know what you're reacting to, but it's going to give you a better reaction than just standing there and waiting for your cue. So if you're just kind of looking around, here we go.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Judge, I'm James Owens, and I'm representing Sarah Boone. Look at that. Looks over to the camera. Did you catch that? I'm being represented.
Good morning, pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now, clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Yes. All right. It looks like my volume's good. Their volume's good. If there's any problem with balance or any technical issues, feel free to bring it up in the chat. I do not mind being corrected. I don't do everything perfectly. I don't excel at everything. But through the help of a fine and dandy chat like yourselves, I've gotten a lot better at a lot of different things. Even approaching excellence, but only with the help of my friends.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Sarah Boone, 10-10-77.
Good morning, everyone.
You can't resist the camera.
Are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open.
Can I have a pen? Oh, this is also funny too. She was unshackled yet unprepared at the last meeting. Well, now she's not pro se. So back to the shackles, babe.
Court on August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed.
So just so you're aware, we're now on September 3rd, 2024. The August 23rd deadline for objections to evidence has passed. James Owens is taking the case, knowing that the dates are set. October 7th is the date of the trial, and the dates are the dates, to quote Judge Kraynick.
On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and...
Thank you, Margarita. The red folder was a hello to Lana. So if you're out there, if you were listening to Tanika's tablet messages rundowns, the red folder was, I'll get a red folder. And when I hold it up, that'll be like Carol Burnett pulling down her earlobe to say hello to her aunt at the end of every show, instead of pulling the earlobe, because I'm not going to be able to do that with my pink cuffs. But I could hold up a red folder for you. Lana, love you forever. To the end.
Where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Castore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items.
So, Sheriff's Office, August 30th was the day that she was able to see the physical items of evidence that are not included with the discovery. That would be the wine bottle. That would be the bat. That would be the suitcase.
With Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense. That was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that.
To anyone leaving the chat, like Pretend Judge, we will be on replay for sure. I'll set a live for later tonight for whatever we end up voting on. But Pretend Judge is going off for a quick dance with the dog, so if anyone else needs to do so. Got about 40 minutes of live video that we'll be watching from this trial, and then we'll stick around for the motion for snacks. That's a little further ahead. That's coming from October, but it's fun. It's a good way to finish off the show. So we'll watch James Owens perform a humiliation ritual for Sarah, and we'll watch the response he receives.
JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's?
Thank you. Carol Burnett's ear tug was for her grandmother. Zeitgeist Amy correcting me. I don't know why she would do a special one just to one aunt. It would make the other aunts and uncles feel jealous, unless it was intended to make them feel jealous. But no, the grandmother, that makes more sense. Just impressed I remember the ear tug.
Pro se motion for costs. Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions.
I'd like to abandon that and substitute it for two others. Take one down, put two up on the wall. Now there's 100 bottles of wine on the wall. They're all empty. But... Oh, and this is because, Sarah, at the last video, we saw her put a motion for like a neuroscientist that was going to study your brain, and, they wanted to talk to the JCS about it. James Owens doesn't want that. What he wants is an expert witness who was in the Marcia Clark trial, and my assumption for that is that Marcia Clark must have been a defendant who recently was exonerated on the charges, and James Owens thinks that the witness is the reason why. And without knowing the case, I'm going to say 100% is probably because the facts that were in evidence were probably a lot more supportive of Marcia Clark, whoever she was. It's probably worth looking into that case too. But in any case, that's what's going to happen here.
The appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had.
We don't need this neuropsychologist that Ms. Boone. Not a good way to endear yourself to your new client.
Requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She's
locked in, Your Honor. I talked to her. She's going to say everything that we want her to say, so We need her at this trial, Your Honor.
An agreement to handle the case, to reopen her file. She has sent me her records.
Candace is telling me that Marcia Clark was the DA that put for the OJ trial. I know that for sure, but I think there's another Marcia Clark. I might have to look it up while James Owens makes his motion for 2 more motions. But I'm sure that one of the witnesses he calls, it was because there's a woman that put forward a battered spouse defense and won, or at least, got pled down to a lower charge.
I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion.
Oh, that's key too. Did you hear that? So I hope after she spends some time with my client, she's going to be of that opinion. She's met with her before and didn't have that opinion. But, I think she's going to have that opinion now. That's an interesting little giveaway, Mr. Owens.
After she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator.
This guy doesn't come in. This is the guy that kept body parts in a freezer in a storage locker or something like that. I remember there was a lot of discussion of him as an expert, and then I don't think he ends up even coming into play.
Dr. Michael Berkeley, who is from my area, Pensacola, is who
from my area? Yeah, I don't think he comes down.
I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkeley. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I punch them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars, the call on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
Okay, I knew Michael Berkland sounded familiar. I look it up, and the best result I could see is a Tanika 2 Cents video. Shout out to Tanika. Michael Berkland is an expert at what? Fired twice, sued, and arrested. Florida versus Sarah Boone. This is an early Tanika video. This is from September 21st of 2024. 5,000 views, 499 likes. Well, you know what? That is getting like number 500. Tanika 2 Cents. If you want to look for that video, look for Michael Berkland on Tanika's 2 Cents, Tanika 2 Cents. And there's an 18-minute long video that only has 5,000 views. I think she could just put out a video with Sugar Bear saying hello and get 5,000 views now. But that's where we were September 21st of 2024. That video was put out 18 days after this. So how quickly was Tanika getting the receipts for people? Even back then, he was only announced at this September 3rd hearing, just brought up for the first time. Wow, that's, I love going down the history lens, and, shout out to Tanika. She's there early and often with the receipts.
I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, and the other three aren't. They were all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning.
Sarah's already lost a little bit of her A little bit of the bounce in her step.
The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how to address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday, and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing the counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client.
Hey, Nano4.
We also sent notice.
Big F you to Nano4. Thank you for joining us. Good to see you. If you see me reacting around like this, at first I thought there was a weed whacker in the background, but there's a fly buzzing around here. Probably only loud enough to annoy me, but yeah, I'm dealing with that.
To as well, that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB, and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the.
So yeah, we've provided discovery 9 times now, or yeah, 9 times now, Your Honor. We'll do it again for him, but just to be clear on the record, we've provided it to 8 lawyers. We provided it to her as a pro se client in jail, and sure, we'll make one more copy for this guy.
That is in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Sure.
Oh, I'm going to take a little pause. Kellia has a great horror reference. The buzz is coming from inside the house. No! Kellia and Luminessa were working on a Rocky Horror Picture series of parodies, including Sarah Boone, and I got some great lyrics for it. I'm not sure what you guys are doing with it. Are you guys looking at doing partial vocals and then sending it to me for arrangement, or do you need me to chime in on a lyric or two? I can help out if it's in my range, but I think we might be doing some sort of fine and dandy collaborative product on a Rocky Horror Picture Show parody to Miss Boone.
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State, you had the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars.
I love the cameraman this day. It would have been so easy just to stay on the person who was talking, but he knew that this is where the story was. Look at her scalp. That's interesting. Don't look too closely, but a lot of times her hairstyle's inscrutable. In this occasion, you can see what's going on. There's this front bang swoop that is, up and over with a tuck, and then a basic side part with incredibly long bangs. Like, she could look like Cousin It probably if she wanted to, and wear like her bangs down like this in front of her face. That's a rare peek at how that, because it's a tough hairstyle. It's not a bob, but it acts as a helmet. I think it's because of whatever she's using to affix it. The fact that you can see her scalp, she's not using whatever dye, like, prison hair dye, shoe polish kind of, where it does, scalp roots and all. That's an interesting little pause screen there.
Formally in writing, given the lack of time we've had to prepare.
Oh, Zeitgeist Amy asks an excellent question too. Just asked how to get to the community tab, and it's worth checking out because I post a lot on my community tab. Basically, you want to go to see the channel. So if you are watching a video from a channel, click on the channel name underneath the channel. So, you're watching this video. Let's see. You can see that little yellow picture with my cartoon image. Flies buzzing around, by the way. If you click that, then it should bring you to the channel page. And then the channel page will say like videos, shorts, lives. And at the very end, it'll either say posts or community. That'll bring you to the community tab. And as long as you're a subscriber of the channel, you're able to post to the to the community tab, to the chat tab. That's what I wanted to say. As long as you're a subscriber, you can post to the community. For the Betty Broderick trial, we did a fun montage of all the pets from the community. So that's included in a few of the videos towards the end of that playlist. But yeah, you can post anything you want on the community tab. I don't have any rules. If it's something you think would be interesting, it'll go up there. If it's not interesting, then, nobody will look at it, and it doesn't hurt me either way. So feel free to post. I like seeing everything you guys have to post so far. Disney Mom posted a great photo of hard-boiled eggs, and I didn't think I'd be saying I ever saw a great photo of hard-boiled eggs, but it's probably the greatest hard-boiled eggs photo I've ever seen. So if you want to check out the community tab, check it out. It's fun. It's fine and dandy.
To make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Berrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Berrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist make a request. You know, I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon.
There we go.
Dr. Michael Brandon.
B-R-A-N-N-E-N.
He's
I loved Dr. Michael Brannon. I think it was almost an accident that James Owens brought him on. Maybe he's the one I'm getting confused with the person. That's probably it, because he was an effective witness. Whatever case Dr. Michael Brannon testified in recently before Sarah Boone's hearing, I think that person got a favorable result, a successful conclusion to her trial, as Sarah would put it. And that's why I'm getting confused. And because I remember, there was definitely the body parts one that I've pointed out, the Tanika video, but that makes more sense because Michael Brennan, he did say a lot of the things that needed to be said for James Owens to establish his defense, like the fact that, he could argue his defense. But as an expert witness, he answered quite honestly when Mr. J and Mr. Cacciatore said, isn't it possible that George was a victim of battered spouse? Well, yeah, no, it's definitely possible. Isn't it possible that he was maybe the only victim? Well, yeah, it's possible too. I'm paraphrasing, obviously, but that was, he gave honest testimony, and I think he hurt Sarah more than anything. Because, if you're a jury and you're trying to judge defense witnesses versus state witnesses, when one of your own witnesses kind of lets the cat out of the bag, no, I think she's, pretty bad person. Very likely she did these horrible things. Anyway, that's, I keep saying Marcia Clark. I feel like it's Marcia something, but, because, maybe the name is just because of the OJ prosecution. It might also be it's a common enough name that it just doesn't show up in search results because, she's someone who got exonerated as opposed to somebody who's been convicted of a crime and stays part of the public record for it.
Spells it Brannon. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County.
Thank you, Marsha Thompson. There we go. Thank you, Mr. Owens. And thank you. It does confirm that I was, half right. I don't excel at everything. B+ student with some C's. But Marsha Thompson is the case. And, this is what gave Sarah you got a witness that worked on a case where the person got off? I also had a roommate who got off on her case by rejecting the plea deal. So now I've rejected the plea deal, and I have the expert witness that'll get me off. I'm getting off. Be eating ice cream with Lana.
First degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch and was acquitted of first degree murder back in July of this year.
Okay, thank you. A little case breakdown too. Husband lying on the couch. She shoots him 9 times and was acquitted. Sarah definitely thought she was getting off.
That was a 2019 case, so that took a while to get to trial. But Dr. Brannon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brannon said victims of repeat violence may fear death in situations others would not.
And?
I'm trying to reach out to them.
Your point, Mr. Owens?
Ran this weekend unsuccessfully, and my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brannon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the...
You see the way she lit up at Billy Lane? I realize I'm pausing a lot. I just noticed that we've been going for, well, many more than 1 hour. But yeah, the minute Billy Lane, she looks over, like she's smitten.
Psychologists. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that.
There's Mr. Billy Lane. I've only got eyes for you.
So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple.
This is actually instructive. We, always talk about the narcissism traits, but, a lot of times it's just kind of casually throwing the word around without a real analysis into it. In this case, it's really clear how the narcissist love bombs the relationships early, and, how she treats those same relationships, 2 to 12 months later, basically when it stops being beneficial to her. So smitten with Billy Lane, lighting up at every time that Mr. Owens has anything to say today. Even by the trial, she's oppositional to him. So you guys had an on-again, off-again relationship? No. Oh. I mean, you guys broke up, you got together, you did the... Yeah. So on-again, off-again. Fine.
So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrests of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation.
Elizabeth asks a great question, and it's a little morbid, but I'm going to opine. Elizabeth, 3236, says, I don't understand why they need a crime scene reconstructionist. George in a suitcase and died in a suitcase. What's to reconstruct? Do you think it's possible that he wanted to demonstrate how George could get out of such a suitcase, and they were going to organize some sort of morbid scene where he would build a suitcase to scale, get himself zipped inside of it with 2 fingers poking out to demonstrate how he could have gotten out if he wanted to? I'm just speculating. I don't have any evidence that's why. But he didn't ultimately get called. And could you imagine what a spectacle that sort of even if it proved that a person could get out of a suitcase that was engineered to get out of from the inside to recreate this specific scenario, how bad it would look for the jury to have them looking at this scene in front of them see? Just as Chelsea said, if he could get out of the suitcase, he would have gotten out of the suitcase. How about that? You don't ask for help to do something if you can do it. We've all seen the commercials from the 80s, help, I've fallen and I can't get up. Nobody did that when they hadn't fallen or, could get up.
It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other, of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these weeks.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance filed that was filed on August 30th. Court's had the opportunity to review that motion.
The motion for continuance. Now, to be fair, you've got to file it, otherwise you're being neglectful as a lawyer, but it was always going to be denied. Judge Kraynick made it clear, absolutely clear, there will be no continuances. This trial has taken way too long to get through the system, and now it's going to be heard.
Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper.
So, it's a real time crunch, but the dates are the dates.
To come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two.
This is the first case of James Owens trying to testify to assumed facts that aren't on the record.
So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going
the old leg stabbing. Yeah. Look into that, Mr. Owens.
Take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday.
So based off of my 3.5 hours with her, despite the fact that nobody in 4.5 years thought the battered spouse was a good defense for her, I think it is. And the only problem is I only have 6 days to make it happen, Your Honor. So if you could help me out here and just give me a day or 2, perhaps a week or 3, I'd really appreciate it. I'm trying to do my best, Your Honor.
As well as the other 4 times that I've met with her.
Deborah Rockhill saying hello, wasn't at the computer to catch the start. We've watched 2 hearings today, Deborah Rockhill. We watched Sarah Boone represent herself pro se, and then we're just got about 20 minutes left in this video showing James Owens' first appearance with her. Before we wrap up today's stream, we'll be watching a little of the snacks motion. It's skipping ahead into October, but it's fun, and it's how I'd like to finish the stream. Then we'll cut back to a little bit more of September with James Owens next Friday. Maybe even with the Cowboy. Congratulations to Cowboy Criminology. He's moving on to 3L in his law career, so good for him. Good for his results in the test. Might have heard that. It almost landed on the mic there. But yeah, good for Cowboy Criminology. Hopefully he'll have a little bit more time, and maybe we can do another one of these together as well. Check out Cowboy Criminology on YouTube if you want Sarah Boone coverage. Just one loud fly.
I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But
now Garita says, I'm just a good old boy trying to get by, Your Honor.
I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone.
So he's trying for January. The date is November or September, so he's asking for a 3-month continuance. And that's why you saw him make his little notation there. Okay, that's what the ask is.
And formulate their opinions. I'm sure the state's going to want to take the deposition.
Now Garita's got some more super chat requests. Just a simple hyper chicken lawyer from a backwoods galaxy, Your Honor.
I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance.
It's going to take a little time, Your Honor.
The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it.
We tried.
My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now,
Nana 4 is from the Milton, Florida area. I hope, was it just named Hurricane Milton? It didn't actually hit Hurricane Milton. It was named that before it happened, right? It was just that it happened to coincide with Milton moving down to delay the Sarah Boone trial. I guess being from Florida, any particular hurricane could be trouble, but hope that you steer clear of hurricane danger this season.
that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts will be ready. And so that's instrumental in our defense.
So that is kind of interesting. He's basically, even though it's going to get denied, so he's going to have to work to get it done, it is a good thing to get on the record that there was a defense that he wasn't able to prevent. He does get to present it, but if he wasn't able to present it because of time, that would be probably more compelling than any of Sarah's current appellate arguments.
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean,
You have to give it.
The rule was created and contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
That is a pretty good spitting image.
No. All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' bases for withdrawal, and why.
Anyone's wondering who the cartoon chicken that is on the screen, this is the Hyper Chicken from Futurama, Hyper Chicken Lawyer, as suggested by Meowgarita as a spitting image for James Owens. So, in case you thought that James Owens was on the inset there, no, that is Hyper Chicken Lawyer.
The court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment, knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February.
Judge Kraynick, he's so quiet in Grey Rock, but when it comes time to sharing receipts, he's like only too ready. He's got everything set up, and like there'll be no interruptions. Just listen to all these times and dates, times, dates, and actions.
February 9, 2024, and as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankwitz Mr. Bankwitz, on July 17, 2023, again by Attorney Collins.
Be right back. There's 15 minutes left of this. I think there's a little bit more, at least enough Judge Kraynick receipts that I can get back to the bathroom. But leave you with something besides a pause screen.
On January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Bargo v. State, 221 Southern 3rd 562 at 569, there's a two-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JACS is not here to have the opportunity to review those. In Ramos versus State, 75 Southern 3rd, 1277, at pinpoint 1281, by the Florida 4th DCA in 2011, citing to Watson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court-appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender.
The court's done its own research as to your experience. Judge Kraynick, just letting them know. You know, I know all about you, Mr. Owens. You have an extensive list of credentials, but I've done my own research, so don't try and good old boy me through this trial. I know who you are.
Judicial circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome of defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state, 311 Southern 3rd, 185 at pinpoint 189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial the 6th or 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion, then...
Just for the record, tune in next week because the first Zoom hearing that James Owens... Hello? Hello? We hear you, Mr. Owens. Hello? Hello? Judge Kraynick? We hear you, Mr. Owens. Judge Kraynick? Margaret hasn't brought James Owens up to speed on how to Zoom into a trial at this point.
Provide a form work, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings.
I have an easy answer, Kelly. Kelly asks, are you north of Idaho or Washington? Now, I'm not sure. I'm north of both states.
When we can appear virtually, JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. You know, I went to the jail yesterday. I had to let them know in advance that I was coming.
This is kind of stupid, too. He wants to see the digital materials. Realistically, we know what most of the digital materials are. Obviously, he wants to see the court copies. But it's not like he's going in blind. The JCS video has been online. The interrogation is online. There's so much of this content that he doesn't need to request access to. It's already out there. You know, you're going to want a real copy of it before the trial, but you've got 6 weeks before the trial. You could view these existing versions of it to bring yourself up to speed. But obviously he's, they're going for time here. They're trying to run out the clock.
I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours.
Kevin Brady just noticed that his shower curtain matches my background. Well, that's not a coincidence because my background is a shower curtain. See how I can show you. Let's go full me. Yeah, so that's my background. That's the true crime window up there. You can see it kind of is attached to the open pillars. Yeah, there we go. There. Oopsie. I didn't
get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to for me to look through the digital evidence as to what I assume it's being redacted. I know some of the audio in terms of comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
Our opinion is that they should get no extra time, Your Honor.
I'm not certain is he asking for
Instead of a continuance, could I just get some extra time?
That he's seeking.
What is it you're asking for? Extra time to do what?
What is it you're asking for?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant.
Mr. Cacciatore is just giving him stink eye. Look at that. He's not blinking. He's not breaking gaze. He's like, you're coming down from the panhandle to fuck our shit up 5 weeks before we're ready to go? Not on my watch.
Defendant's investigator no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
I'm not asking for a continuance, Your Honor. I'm just asking you to reset the deadline.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide
Margie 420
Ex Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now,
again, just going through the list, like, you know, these are all dates within the last 6 weeks. This isn't like a, 2.5 year rundown of the case. That was starting from August 9th and leading up to today being September 3rd. So plenty of opportunities to have your discovery before this. I need to see it digitally on my own, Your Honor, please.
Under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those
hey,
would be extended
KR4.
by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review this?
Speaking of time, we're just going to watch the snacks hearing. We only have a couple of minutes left in this video. And then we'll be cutting off this stream. In about 8 hours, we'll come back. And we'll just do a shorter, fun, random body cam. I don't know when I'll go live. I'll go live when I'm ready to go live. That way I'm not panicked and stressed about it all day long. I'll just casually get in there for a ramble. But we're probably about 20-25 minutes from the end of today's program. Marathon Friday morning. Thank you for joining me. I didn't expect it to go this long, but it's amazing how much more you have to say about these early trial coverages that didn't get as much attention once the trial happened and we started rewatching the trial in full. Guarantee that fly will be dead by the show in 8 hours. Sorry, I'm not a killer, but you can't mess with the show.
States digital evidence that it seeks to admit into evidence and tender any objections.
I've got
A fly killerer.
a live jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client.
Remember how happy she was at the beginning of this day? Even though we've been here for many, many hours, in this particular video, she's only been here for an hour. She came in from just walking on roses, walking on sunshine, people throwing flower petals at her feet. Now she's like, this guy's a dud. We're not getting anything. Lana told me he'd be good. He's no good.
I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State.
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure. State, anything else?
Not this time, Your Honor.
Madam Clerk's going to work dutifully to, it's already done.
It's already done, Your Honor.
I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file a response to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. Y'all can have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word?
Disney Mom fell asleep, but that's fine. That's fine. I bet that is a little bit of an insight into how you were able to prepare those hard-boiled eggs you posted on the Dan D community tab. The propensity to fall asleep while doing something else. But don't worry, Disney Mom. You've joined us for the fun time. We're about to... Oh, I contacted it. It touched the back of my hand. Okay, I sent a message. Anyway, we're going to watch the snacks hearing, and then I'm going to take a break. I'm going to have a bite to eat. I'm going to maybe go wash the car, do a little grocery shopping, and spend time. I have a sanctuary out back. I feed homeless animals, mostly birds. Well, all the homeless ones are birds. The ones that have a home live here, but and they're not birds. It's a cat and a dog. But I feed homeless birds. That's what I do, you know. I have a sanctuary, so some of your donations go towards the funding of my homeless bird feeding operation. That in mind.
Absolutely.
Oh, there's whispering. There was whispering. Okay, what did she say? That could be the little piece. Sorry, guys. Go back 7 seconds. Slow it down. That'll increase my personal volume. The hell was that? Slowing it down did not help. So we'll go to She asks for something, puts it on top of her papers. Huh. Well, now the audio is off because it's the courtroom audio that's off, not just me. So we'll let that play out while I talk it out. Just a note about time. So normally, like the reason I try and do 2 shows on Fridays is to appeal to as many time zones around the world. So not just the North American, which tends to work out. You know, the morning shows or afternoon shows if you're on the East Coast. The evening shows are maybe a little late if you're on the East Coast. But I did the morning show, so you don't have to depend on the evening show. Okay, that's it for that. But I try and move it around a little bit so that between those 2 times, you're getting a lot of opportunities to either watch the show live or on replay. Or do we got to skip for the... There it is, snacks. Okay, so we only have about 15 minutes left to show.
To the suitcase murder trial. Trial not opening up just yet. They're still working on getting that jury seated. They started on Monday. They're going to continue today.
Sounds
they
a
have a
little quieter.
motions hearing set for 9:30. Apparently still
Oh, so
some
that's
outstanding
studio audio.
motions, and then they're going to continue picking the jury in the afternoon. And in case you didn't hear, Sarah Boone filed a motion requesting snacks at her trial. And answer from the judge this morning about that. Take a listen.
Yes, sir, Mr. Owens.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart. To allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break.
She doesn't have any medical issues, but she feels like those items might, during a break, help keep her energy up. I can see that my connection is starting to get really slow on this, but we're going to power through it because there's not too much left to go. There's a little bit of banter between the hosts. I'm going to skip those parts. If you want to see that, maybe I'll post the link to this video. Go up there and grab it now in the chat. And if you want to see the Snacks Motion video with their commentary in full, you can watch that after we go offline. And the night shows, it's not always like right now. I see that, we're already at 3 o'clock, so it's going to be an evening show. But some Fridays, if I do my morning show like at 5 a.m. West Coast time, which would be 4 hours earlier than we started today, then I might do an evening show as early as 3 p.m. my time, which is 6 on the East Coast, so that I'm able to, go watch a hockey game or do some evening things. So I'll move the times around. There'll be opportunities for people to enjoy both the morning and night shows. They have a different vibe. The morning, I'm a little bit more coffee and smoke medical snacks. The evening, I'm more mixed drinks and smoke medical snacks. I guess it's not that different.
that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not the state attorney's office and any of the parties involved.
Okay.
We have no
I
response.
will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right, anything else?
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks. She's not going to the movies. She's going to her homicide trial. And she's being specific. She's going, I want, 5 peppermints. I want to have a Pop-Tart or some cookies, 2 bags of potato chips. Get real. This lady's unbelievable. What about the sadness she might feel for her boyfriend, George Torres, who lost his life? He doesn't get to eat anything. And by the way, the jail is sending over meals for her. My understanding, 2 meals to be sent over. So it's not like this woman is starving. She just must think she's special. Let's bring in our attorney guest to talk about this. Very seasoned trial attorney. He was a homicide prosecutor, Randolph Rice, on the program
All
today.
right, so you can watch
Randolph
Randolph on your own.
This lady, the nerve with her.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30.
Center and that whole process. So I think that is probably the way to go.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30 today to try to figure out what the issue was with the clothing.
There's always an issue with her, Randolph, as you know. Would you speak to how things typically go when you're getting a client ready for a trial, and if they're being held in jail prior to the start of the trial? Certainly.
Try one more refresh here.
Sarah Boone in court.
Okay.
Instead of going and then pick them up in the evening, the clothes she wore that day, that would. They expressed to me that if I would just bring her clothes every morning, whatever she wanted to wear, and then pick them up in the evening, the clothes she wore that day, that would work with them instead of going to the visitation center and that whole process. So I think that is probably the way to go.
The Owens is both making a ruling or a motion on snacks, specifically 5 peppermints, 2 cookies, as well as asserting his right to deliver her wardrobe.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30 today to try to figure out what the issue was with the clothing.
There's always an issue with her, Randolph, as you know. Would you speak to how things typically go when you're getting a client ready for a trial, and if they're being held in jail prior?
Forgive me, Your Honor. Could you please repeat the question?
Sure. The question was, without going to any specifics about conversations that you've had with you and your attorneys, are you in agreement with the persons that have been identified in that list that may be called as witnesses in your case?
I'm not familiar with everyone that's on here, but I do agree with whoever it is that they have on here.
Okay.
Okay.
Ooh, okay. Randolph, she's, she's, what do I want to say? What's the expression? Dumb like a fox, right? She kind of played a little dumb there about, well, I don't know who's on the list, but I guess I agree. Do you think she's trying to set up some kind of post-conviction relief for herself or ineffective assistance with some of these comments she makes?
I certainly think she is. She is probably trying to lay the groundwork for either a appeal or complaint against her attorney saying that they didn't provide me this information. I never got to look at it. And that could certainly be a basis for an appellate court to look at this case and say, well, you know what, we need to certainly think she's being cryptic. I think she's maybe me, please.
Yes, Randolph, absolutely. You just television to you right now. Yeah, we should get snacks, right? We don't snack, we do our
No, this judge seems to look at the law and what the courts have said and to make reasonable.
Or juice.
Julie, a peanut butter and jelly sandwich, and it sounds like she's even getting cookies. I don't even get cookies during my lunch, so she's doing better than we are.
We got to talk to somebody about that. We got to get some cookies for Randolph Rice and some Pop-Tarts. You're the.
You know what? We will return with the ruling on the snacks motion, maybe even to start the evening show, because I fucked that up. That's where they talk about the snacks motion. That's where he makes the snack motion, but it's not the video that has the ruling on the snacks motion, which is denied. But yeah, that's another video for another stream. I can't believe we went this long. I meant to go 3 hours, 4 hours today, but we went for 5.5 hours, which means I'll be back in 6 to 8 hours, and we'll spend another couple hours together. There was a vote. Do we want random body cam or a more organized deep dive into Carly Gregg? And it's random body cam. So we'll get to see the woman in the gas station that evades police. That was featured on Midwest Safety. Watch a little bit of Code Blue Cam. We'll watch a number of egregious criminals. But we'll start it off with the Sarah Boone snacks motion, because I got you guys hyped up for that. So if you miss out, you can watch the replay of the night show and make sure you get to see the snacks getting denied. We had over 100 people in the chat today for a rewatch. Thank you. Thank you, thank you, thank you. To everyone who's here, everyone who's watching on rewatch, you guys are fine. I'm Dan D. This isn't quite the end of the stream, because I used to just say this is the end of the stream, and then I'd watch it and see that it was like cut off entirely. So I need to vamp a little bit after saying that. But you guys are fine, and I am Dan D, and this is getting close to the end of the stream. This is maybe the time where I acknowledge the fact that Meow Garita and Hairball Yarn, who just joined and got their Drunky the Bear badge today, are here in the chat. Kitten Pusher had a good time. Good to see me. It's good to see me. That reminds me of Betty Broderick as she was signing her cards. Like, want to hear from you. Love me. Bye. Love me. Love me. Love me. Detective Wolbafit right here to the end. Care for JC YouTube. Got Kelia, Disney Mom, who woke up for the end. And definitely check out the community tab to see her hard-boiled eggs. That is the most amazing picture of hard-boiled eggs I've ever seen. Had a lot of people who've had a great time today. I think I do need to get some snacks, so I haven't had any medical snacks. I had lots of medical coffee, lots of medical cigarettes, but I'm not going to be fine if I don't eat, and I need to be fine because together we're fine and dandy. The stream's been fine and dandy. Bill for Dom Russo's had a fine and dandy time. He's been here for a lot of the stream. Bella's mom's been here, just checking in at the end. A to B. Tammy Zellen, thank you so much for coming in to say hello at the end. I appreciate it. There's a lot of people that are enjoying some Dan D for, maybe the first time in a while, and I appreciate you all being here. There's some good videos too. If you go onto my community tab, Wordwise just released a new video. Haven't seen anything from Wordwise in ages. It's about an hour and 40 minutes long on Corey Richins. Great video. Speaking of Corey Richins, back to that screen. Can you believe that McKenzie Shirilla wore the Corey Richins for her documentary? Like, yeah, I want to look super guilty, so while I'm proclaiming I'm innocent, I want to have a side part the exact other direction of Corey Richins, because hers is to the guilty side. So if we could just, make mine to the innocent side and hers can be to the guilty side, I think that'll work best. I think that'll work for everyone involved. Who would intentionally choose the exact same hairstyle as somebody who just got convicted of an awful, heinous murder? Oh, McKenzie Shirilla would. That's who would do it. That's who would do it. Okay, I think that's enough bonus coverage. I think I've had a chance to really say that you guys are fine. I'm Dan D, and that wasn't quite the end of the live stream, but is very close to the end. For everyone who's still here, Victoria Carmen, it's been great to see you. one of the Betty Broderick joinees of the Dan D channel. It's great to see you. Great to see everyone who's been here. I'm going to see you again real soon because it's Friday. And you get D twice. DD, Dan D. 2D Friday? 2D. Yeah, it is 2D. This isn't 3D, right? You only get the height and the width. There is some implied depth, but realistically, it's not. You're watching 2D. 2D Fridays. Work on it. Work on it. I've had a really good time. I think the chat will stay open for up to 3 minutes so people can say their goodbyes. But I'm going to close the video stream and count it down from 10, 9, 8, 7, 6, 5, 4. Care for JC has seen puddles less shallow than her. 2,